Thank you for bearing with us for our technical issues this morning. I'd like to call the meeting of the Planning Board of Tuesday, March 25th, 2025 to order. Again, this is a hybrid public meeting. In person, we are at the Norton Town Hall at 72 East Main Street. There's also a Zoom link available in the meeting agenda to join me directly or with the meeting ID 638-929-1060, which is the same code it's been for the last 5 years. The meeting will also be available on Norton Cable Access and the Norton Media Center's YouTube page after the conclusion of this session. I'll ask that anybody joining remotely, please mute your lines during the meeting unless you're asked to speak, so that way we can keep background noise to a minimum. For future sessions, please feel free to email questions for the board ahead of the meeting to Brian Carmichael, town staff. They can be forwarded to the members in advance of the session and reviewed. So with that out of the way, I'll call everybody to order here. I do want to start with some overall announcements. In the first issuance of this agenda, we were going to be discussing 2 articles for the town meeting warrant. We will only be discussing one of them. Zoning Article 9.7 for the multifamily mixed-use overlay, otherwise known as the MBTA Communities Bylaw. That is going to be continued to April the 8th of 2025. The Sun Chronicle did not post the notice of this meeting appropriately, so at the advice of Town Council, we are continuing that to April the 8th. There will also be an additional informational session on April the 1st. That will be with the Select Board and other town committees as well. So if you would like to join that meeting, you are certainly welcome to. Also want to let everybody know that of the 3 public hearings additionally we had scheduled this evening, earlier today we received requests for continuances for the projects at 1 Dean Street, as well as the project at 361 Rear Old Colony Road. 1 Dean Street is requesting a continuance to May the 6th, and 361 Rear Old Colony is requesting continuance to April the 1st. So if anybody has joined us this evening and is looking to speak on those sessions, we're not going to be discussing them tonight. Paul, is there anything else that you wanted to add in terms of the housekeeping with those items?
No, that's all.
Okay, thank you. Okay. Everybody on the board clear on what we're doing here? So, okay, perfect. So with that out of the way, we'll save planning board business and policies for the end. I don't believe we have any bills or warrants to approve, and we'll move minutes to the end of the meeting as well as we did with our last session. So with that said, the first item up is our public hearing for our upcoming town meeting warrant. And the one item we are able to discuss this evening is our continuing discussion, and this is the official notice meeting for this session, on the recodification of our zoning bylaw. And this is to create purpose and authority districts, use regulations, dimensional regulations, and review non-conforming uses and structures, general regulations, special residential regulations, special and overlay districts, administration and enforcement, and definitions. So with that out of the way, I'll introduce Mark Bobrowski, who's been the attorney working with the town as part of this project. To get started with an update, Mark, I guess if you or Paul wanted to just give an introduction here. Sorry, I presumed.
Yep. So Mark, my laptop now is being used as the projector, so would you be able to share the documents?
Oh, I thought you were going to have it teed up. Let me see if I can. I didn't set it up, so I got to go in and try to find it.
If we can just knock the volume down a couple of notches while we do that.
Tim knows how to clear a room.
What is the name of the doc?
Great comedian.
I think it's draft 8 with highlights.
Okay. I'm going to look too, Tim.
Okay, thank you, Rob.
Well, let me just open the use table as well, because we'll need it later.
Perfect, thank you. Okay, and I do see additional people joining the Zoom meeting. I'll just say again that if anybody is joining, looking to add comments regarding the multifamily mixed-use overlay district, otherwise known as the MBTA bylaw, the Sun Chronicle did not properly post the notice for this as the public session for that discussion, so we will not be discussing that article this evening. But we will be discussing the zoning recodification bylaw.
All right. This should work, I hope.
We are seeing your share, thank you.
Great. Paul, do you want to make introductory remarks, or should I just start in?
Just started, Mark.
Okay. Good evening, everybody. Mark Bobrowski. My office is in Concord, and I'm pleased to be working with the planning board on the recodification of the Norton zoning bylaw. This is draft 8. There are a couple of small issues that we had left from a discussion. I believe they've been resolved, but I'll use this for the purposes of going forward tonight. The planning board has had innumerable meetings over the course of the last 12 months, certainly. And the product that you're seeing is as a result of the thematic meetings that we've had over the course of the last 12, 14 months. So typically what we did was prepare a memo in advance, highlighting some sections of the bylaw. We went through them. The planning board fired questions, made suggestions for edits, and then I prepared the next draft. What you're seeing is, as I said, draft 8. My usual format for the public hearing is to just walk through the bylaw section by section. So we'll start with section 1, purpose and authority. I'll stop or pause if there are questions. If you have a question or a comment, please use the features of Zoom, raise your hand. The chairman will recognize you. And the idea is that when we close down the discussion of section 1 and move on to section 2, we're not going back. We're generally just making progress as we go through. I would say that about 70 to 75% of the bylaw is existing material that has just been renumbered, moved into a better location to make the bylaw more user-friendly. But about 25% of it is new material. For example, section 5 on nonconformities is an entire rewrite for the most part. There's also a new section on performance standards that takes up quite a bit of the bylaw now. So without further ado, I'm going to start with section 1. And my purpose here is to tell you what I think is new, whether it's major or minor, and then see how the audience responds. So section 1, purpose and authority, is typically called, at least in my world, the handshake of the bylaw. It's just a way of getting started. You can see that the title of the bylaw is announced there. The purpose clause is something that is less than fully comprehensive. There is a provision in the uncodified 1976 legislation that suggests purposes for which the bylaw may be used. But remember, we live in a state that is home rule. So there's no limitation on what the bylaw can do as long as it's not inconsistent with or preempted by state law. And these are things that have survived the cut, more or less. And I think these are pretty consistent with what you had in your existing bylaw. Authority brings into context of Chapter 48, which is the Zoning Act, and secondly, Article 89 of the amendments to the Constitution, which is known as the Home Rule Amendment. Compliance required. The bylaw certainly has its jurisdiction, but as is the case in most places, if there are other rules and regulations in effect, they do not bow to the zoning bylaw. They're to be read in conjunction with the bylaw. Amendments are governed by Chapter 48, Section 5. and we're just reiterating that. There is some local flavor to that with regard to section 1.61, 162, 163, 164. These are entirely provisions that are in your existing bylaw, and we just moved them over. They seemed useful. Severability, many of the individual features of the bylaw have their own severability clauses. I've eliminated all of those. You only need to say it once, and that basically is that if a bylaw provision is held to be unlawful, the rest of the bylaw stands on its own merits. So I'll ask if there are any questions with regard to section 1.
I think just for context in some of your earlier comments, and if you want to, we do have one person here in the room who would like to ask a question. I know you've said that the purpose clause and kind of the handshake of the bylaw has generally not been found in court to actually give residents standing to, if they feel that they've been wronged by a decision, correct?
Yes, I had a case last year, the appeals court decided, called Pobeda RT. It's an LLC in Watertown. They filed an appeal of an 85,000 square foot R&D development proposed and approved by my client and approved by the Watertown Planning Board. The Pobeda claimed that their nearby property would be devalued as a result of the special permit. And it's been held now by the Supreme Judicial Court in at least 2 cases, Kenner and the other one is a 40B case, Standardwick, that the protection of property values is not within the ambit of the zoning statute. It's not a zoning related injury for purposes of claiming standing. The Watertown bylaw actually had something to the effect that protection of property interest was a purpose of the bylaw, and that's what Pobeda hitched its wagon to. But the court said even though there was a statement in the purpose clause that protection of property interest would be a purpose of the bylaw, it was to be construed as a general purpose, not a purpose that was equivalent to an injury for standing purposes. So I think, you know, when neighbors sue neighbors, the purpose clause takes on an unreal importance. It's not that important. What really counts for purposes of standing are whether or not the injury claimed is zoning cognizable, traffic, lights, noise. Those are the typical things that give standing. And protection of property interest is not.
Thank you. And we do have one question in the room here, so I'll ask that person just to introduce themselves, and then maybe we can scroll to the related section.
Lawrence Seagull, 28 Cotting Road. I'm looking at section 1.1. I believe in our current bylaw there's a specific provision that butters within 300 feet of an amendment affecting them are to be given notice. This bylaw does not pick up that language and only refers to 40A. I tried reading 40A a couple of times. It's pretty long. It gives notice to abutting towns. It gives notice to be posted. I didn't see the notice to abutters, and I just asked, is that somewhere within 40A, or is there somewhere else in the statutes that apply to that? It is currently in our zoning bylaw, and I don't see it in this current draft.
Were you able to hear that?
I think I heard most of that. It had to do with the provisions for notice and whether or not abutters are entitled to notice of amendments. The provisions of Chapter 48, Section 5 do not call for abutter notice. In fact, the provisions of Chapter 48, Section 5 don't even call for notice to the owner of the subject property. Now, obviously, the owner of the subject property might be the sponsor, in which case that wouldn't matter. I actually had a case in Cambridge years ago where the city council decided to rezone a piece of land on the North Cambridge rail line, and the motive was the neighbors claiming that if it were to be built out, it would be built out too densely, based on a prior development that they had all watched. The owners of the property were a brother and sister, one in Chicago, one in Dallas. They never got notice until after the city council had rezoned the property, and there's nothing illegal about that. That's what the law says. So my rule of thumb with regard to procedures is if it's something covered by the statute, that's fine, you can reiterate it, you don't even have to mention it, because the statute will control. But if you're gonna start inventing local procedures, you're just inventing trouble. Why would you say that the notice of the zoning amendment has to be sent to abutters? Chapter 48, section 11 calls for notice of a special permit hearing to be sent to abutters within 300 feet, and persons who live directly across the street from the subject property. Why would you pick abutters and not all of that? Why would you stop at that? Why not say 1,000 feet? Why not say the district? So you're headed down a slippery slope by inventing procedures. The statute's difficult enough. Let it control, and you can go with the case law that way, because any mistake that could be made has been made. But when you start inventing new procedures locally, I just find it to be very troublesome.
With due respect, it's not an invented one, it's one that's...
Can you speak into the mic?
Sure. It's not an invented one, it's one this town has been using ever since I've been here, and I can't see having an amendment. If it's an overall amendment affecting the whole town, no notice is required. But if I'm doing a spot zoning or zoning in a particular area, I'm shocked to find out that the owner isn't notified, and even then, the immediate abutters aren't given notice. And I would urge the board to leave in the language we currently have, and I would really oppose taking it out at this point. Thank you.
Thank you, Mark. Okay. Mark, would you like us to discuss that amongst the board at this point, or would you like us to save that and discuss that in a general discussion after we go through the rest of the document?
Well, I didn't hear the gentleman's comment entirely. Could you just make a summary of it, Mr. Chairman, and repeat it?
I believe his position was that the existing regulations around what was there has been there for a while, and he feels that it's been useful for the town and is in favor of it staying. Do you feel that's accurate?
I've already said my piece in terms of a general principle. If the board obviously wants to restore something that's in the zoning today, even though it's not required by statute, that's a choice for you to make. And I would urge the board to either decide now, or I'll make a note to myself that we can come back to that, or we can do it at the end. Obviously you don't have to close this public hearing this evening. You can make a list, come back at your next meeting with a simple notice to the public that you're going to be continuing the public hearing, and then you can go back and revisit these questions when you have an evening that's conducive to that.
Understood. Yeah, no, we're definitely aware of that. Just making sure from how you're looking to go through this evening. If you're flexible either way, I'll look to the board if they'd like to discuss that specific matter now, or if we'd like to take a running list and review those directly.
I'm okay with discussing it now. It seems pretty quick.
Okay.
Do you want my opinion now?
Yes.
I'm in favor of restoring it. I think it's fair to alert people when a big change is going to happen.
Okay. Other thoughts, comments? Paul, does this present any challenges for you from as the noticing agency in town?
This is what we've been doing for years. It would make our life a lot easier if we didn't, but I believe that this is the most effective way of reaching out to the public is through a butter notification, and certainly not newspapers. Sorry, that was snarky.
That's okay. Additional comments from the board here?
I'm comfortable following council's advice and keeping it out.
Okay. Any additional thoughts?
I keep it in.
Okay.
I have my hand raised.
Yes, I see that, sir. We're having a board discussion with the board at the moment. I'll call on you in just a second.
Thank you.
Yeah, I think for this recodification, we should probably leave it in.
Okay. So with that, we have Rob, since you're remote, I want to make sure that you have the opportunity to weigh in if you feel as if you have a strong opinion here. you're speaking, you're muted at this moment. Okay. I'll come back to Rob in just a second.
I'm sorry, I'm here.
Did you have a specific inclination about the inclusion of noticing requirements in Article 1?
I did not. I was just kind of listening to that without an opinion either way,
Okay.
to be honest. And sorry, I kept talking on mute like an idiot.
Technology gets the best of all of us sometimes. Okay. I think I'm not opposed to leaving it in. So I would essentially, by an informal vote there, we have 4 members who are saying we're fine keeping it. So at this point, I think the desire of the board would be to include that noticing requirement in the bylaw. Mr. Borowski.
So just using this as an example, Mr. Chairman, I'll prepare a list of floor amendments. Paul and I can get the format, so that I'm not making the moderator mad. But these, having not been advertised, are most likely to be covered in a comprehensive floor amendment to introduce the article.
We have not
Hopefully we
submitted
can.
final language for the warrant yet.
Final language hasn't
Okay.
been submitted, and we're well within the scope of what's been noticed.
Okay, that's fine. Then I'll just make the changes and we'll do a draft 9.
Okay. And I do want to just get to the person on the Zoom meeting who raised their hand. If you can just state your name and address, please. The name on that's coming across from your device is not doesn't work.
I understand. This is William Farrow at 16 Mansfield Avenue.
Thank you.
And you're welcome. I just wanted to comment that we are also in favor of keeping the notice to abutters in the bylaws.
Thank you, sir.
Thank you.
Okay. Anything else with Article 1 that anybody wanted to discuss? Hearing none, let's move on to Article 2.
So section 2 is the list of districts, establishment of districts in town. These are pretty much unchanged. There is some discussion to be had over the wetland protection overlay district, but it's more substantive than it is procedural. I think that there's a new map to be adopted, and that's reflected in 2.3.2. And then there's some wisdom on what happens when a lot is split by a zoning district boundary. I believe that's a new provision that we added because it was unaddressed before. And it's a typical provision that says you can go 30 feet into the more restricted district with the rules of the less restricted district, provided it's a special permit issued by the Zoning Board of Appeals. And that's about it for changes and substance here with regard to Section 2 districts.
Okay. And any comments from Article 2 here from the board? Open items, questions?
Is it confusing do we have zoning board doing special permits anywhere else? Usually, I remember it being a finding and not a special permit. Never referencing zoning board having special permit granting authority.
There were some areas where we've modified it that the findings are now special permits issued by the plan,
Just
by
change
the
it.
ZBA.
That doesn't matter in the town charter, even though it's only one board giving special permit granting authority?
The statute allows for 3 special permit granting authorities: the Select Board, Planning Board, and the ZBA, obviously only where they are designated to serve in that role. You can't forum shop. You can only follow the instructions for who to apply to.
Thank you.
Okay. If there's anybody in the Zoom meeting who wanted to speak here, I'll just open it up to them. I did see one message in the chat saying that somebody was having trouble raising their hand. At this point, I'll ask that person if they'd like to unmute and just state their name and address for the record, please. But just as a point of clarification, comments in the chat are not part of the record for this meeting.
Janine Izzo, 13 Margaret Drive. Yes, I'm just, I'm unable to, I don't have that feature on the Zoom for some reason. So will you be opening up time for people to comment during the meeting?
Yes, is there a specific item that you wanted to comment on?
Not yet, no.
Okay. If there is a point where you'd like to comment, the react function is, on my screen, it looks like a heart, so you can check under there as we go through the meeting here. Otherwise, if you do put something in the chat, we should be able to see that you're looking to speak, and if I don't acknowledge you in some way that you can hear, please feel free to just unmute and say, excuse me, and
Okay.
snap me out of my whatever I'm zoning off on. Thank you.
Okay, thank you.
Okay. So I don't think we have any comments on Article 2, so I think we can move on to Article 3.
Okay, this is the section that introduces use regulations. Obviously, it's to be read in conjunction with the table of use regulations, which I also have teed up, so let me go through these provisions first, and then I'll put the use table up and we can go through that relatively quickly. The use table has a new key. Board of Appeals is BA, Planning Board PB, Select Board SB. Where the board is designated as a special permit granting authority, you'll see that in the use table. There's a provision that you have now regarding special permits for certain uses, and this basically is tripped by 10,000 square feet or 25 or more parking spaces. Anytime that happens in several areas of the use table, a special permit is required, and I believe that that's planning board in all instances. The general rule for the use table is that uses not specifically listed are not allowed. I had a case years ago in the town of Charlton. It involved accessory uses and whether or not the same rule would apply for accessory uses. In other words, did you have to list all of them, or could a more general approach be taken? The appeals court, following the ruling of the land court, held that other accessory uses are allowed, whether they're listed or not, provided they meet the definition of an accessory use, which is a use customarily incidental and subordinate to the principal use located on the same lot. So when you look at the use table, there's a short section of accessory uses listed, but many more are allowed. I think that's the ultimate test. Home occupations have not changed. They're in section K, that's the accessory use section of the use table. And then this provision here with regard to solid waste, there's a state law to this effect. No facility defined in Chapter 111 shall be permitted unless the facility is entirely within the locus and was prohibited prior to July 1st, 1987. So I've seen towns forget to include this again in their recodifications. The AG catches you every time, and not this time we put it in. So that's the sum of this. Now, if you'll just let me stop sharing here and go over to the use table, Mr. Chairman.
Thank you.
I can get that. So here's the use table. The yellow is an issue that we were reserving or talking about. I think this one has been resolved. It allows for mobile homes, if I remember correctly, as a temporary use where the house is being rebuilt. And so I don't think there's any importance with regard to that yellow. We've broken it up into different categories, hopefully making it easier for you to find these uses. So residential uses are in A. Senior housing is a new use. I think bed and breakfast might be something that we've tweaked a little bit. Other than that, everything is pretty much what you have. The mention here of an ADU is to follow the new state law with regard to ADUs that required you to take action in February or at the earliest town meeting. Community facilities are generally those uses which are associated with either Dover Amendment protection or which are quasi-monopolistic public utilities. So every school or church or child care center, many people don't know this, child care centers enjoy the same protection as religious institutions and educational institutions because the legislature deemed back in the late 1970s a serious shortage, I'm quoting them, with regard to good child care. Public services, public utilities fall into a similar category. They're not protected by the Dover Amendment, but they are quasi-monopolistic. Municipalities typically protect themselves by allowing for public uses as of right in some districts and perhaps by special permit in others. Hospitals, cemeteries round out the list. Adult daycare is also both a principal and an accessory use, so it's listed in two places here. Just moving down through the table. Agricultural uses largely reflect what you have today. It was a little complicated. We talked about amending this to edit it a little bit, but when it came time to edit it, each of these things, although it looks alike, did regulate something different. The rule of thumb here for agriculture is that if it's on 5 acres or 2 qualified acres, a qualified acre is an acre that produces $1,000 of gross proceeds in a calendar year, then it's allowed. You can't regulate it. If it's under 2 acres or 5 acres or 2 qualified acres, then you are allowed to regulate it. And you can easily see why a town would want to regulate it. For example, look at number 4, the raising and keeping of livestock, excluding swine. That would, on a 1 acre parcel, would be an unpopular thing, let's say, in a residential district. And these are the regulations that you have today. I believe here now the second town I've put in a regulation that regulates poultry, not including roosters. So you're going to have to tell me how that works out.
That's been there for a few years, so.
Yeah, but I play tennis in Sudbury, and whenever a bad shot goes off at 4 o'clock in the afternoon, a rooster across the street starts crowing. So good luck.
Well, if you go back, I think 8 years or so, all chickens were by special permit. So if you wanted 2 chickens in a coop, you needed a special permit. So whatever it is now, it's better than it was when I joined the planning board to start.
Good.
Steve, I think you had a comment just on the agricultural table?
Yeah, I think, was it uses number 2 and 3? Can you go up to that on agriculture?
Say it again.
Uses 2 and 3?
Horticulture, floriculture, minor agriculture, nurseries, greenhouses, tree farms. In our current code, there is no stipulation for property size. That needs to be removed.
So there's no size qualifications for 2 and 3?
Not in our current code.
Okay. With the understanding that if it was
Well,
greater than 5 or qualified 2, then it wouldn't be.
If there's no size qualification, then it would, the whole purpose here is to say that if you've got 5 acres or 2 acres, then you can do it. If you don't, then are you still going to allow unlimited, in 2 and 3, unlimited activity?
Yes. That's what our code says right now. If somebody wants to fill their entire yard with flowers, I'm okay with that. That's not a special permit situation, and it's already what our code says.
All right, well, I'd take that as a motion or a suggestion that 2 and 3 be all wise for the board's discussion.
Is it for all wise, or is it just, Steve, are you just looking to remove the size qualifications on 2 and 3?
I'm not changing any permitting as it exists. I'm just saying there is no qualification.
Related to the text here?
Yes.
So it's not changing any no's to wise. It's just stating, I mean, if it's over those limits, it falls into number one. So by definition, anything under that falls into those buckets, correct?
Yeah, if you got 2 or 5 acres, you automatically get to do all this stuff. But
So
we are allowing smaller properties, anybody under 2 acres, to grow flowers or have a greenhouse. That is what our code already says. This change is a change that I don't agree with. I don't want to make that change. I'm not arguing to change something, I'm arguing to not make a change.
Okay. Okay.
I also completely
Understood.
redid the agricultural code and it got skipped over. I've had these explanations before.
Okay.
So I'm just trying to correct a mistake that exists now being created.
In the text, yes. So, to your point, number 2 would read horticulture, floriculture, and minor agriculture, period.
Yes.
But horticulture and floriculture are already in the definition of agriculture as defined in General Laws, Chapter 48, Section 3. The
Correct.
statute says floriculture, horticulture, agriculture, viticulture, aquaculture, so they're already included in that.
And does that
So
statute
further-
stipulate that the property has to be qualifying acreage?
So,
Well, I think what you're saying in number 2 and number 3 is even if you don't have a qualified 5 acres or 2 acres, you can do these things. And that's an important, so we're not changing that if that's the case today. We're just pointing out that they're not, they're not on a 5 acre parcel, they're more than 2 qualified acres.
Yes. Keep the current code,
okay.
is my opinion.
I don't think that we're looking to potentially final vote on this tonight. So, Paul, can you just make a note, or Brian, just to note to have a side-by-side of the agriculture table? And that'll be one quick look. Does it say A or B? Okay. So, Mark, moving past agriculture, the next table is,
Indoor and outdoor recreational uses, so here's where the 10,000 square feet or 25 parking spaces kicks in number 1. And then you've got some uses that would meet the description: day camps, non-commercial recreational uses such as parks, beaches, etc., small-scale indoor recreation, and outdoor commercial recreation, which would include tennis and other playing courts. And then indoor, and these terms are defined in section 11.
yeah, so one of the big changes with the recodified bylaw is that all of the definitions are in one section in the back rather than scattered through all of the chapters that make everybody play Where's Waldo.
I would also like to take a sidebar for that category, for the recreation table, possibly later, to explore the definitions as they match. There's new categories with commercial facility, indoor, or whatever. There's a couple new definitions and categories.
Okay. Well, if we're gonna get to chapter 11 at the end of this, we can either touch it then or we can touch it as a sidebar.
I'm fine either way, but just prepping it.
Understood.
Comments on the way, or?
If you want to come up and get ready, I think we'll just get through the use table and then we'll go for it. And so, Mark, if you want to keep going with office and then retail and service uses.
Okay, so office uses, again, 10,000 feet, 25 parking spaces, special permit. Offices are a little bit more broken out than what you have today. I believe we added medical office to differentiate it from a business office, although they're regulated the same in the use table. Generally, you want to have different regulations for parking. When you go to the doctor, you're 8th in line. When you go to a business office, you have an appointment. That's the difference, it's parking. Companies engaged in life sciences enjoy special mention in your current bylaw. Banks, financial institutions, conference centers in the existing. So retail and service, there's the 10,025. Retail establishments are regulated, along with personal or general trade establishments, body art establishments. That's an issue of First Amendment rights. In food and beverage, we've got the 10,025 parking spaces, again, restaurants, nightclubs, fast food, artisan food and beverage, and brewery or winery. I believe the brewery or winery is new, if I remember correctly. Motor vehicle, light service would be equivalent to what today is called in the business a combo. Combos generally are convenience store, gas, and some sort of drive-through service in the window. There is a drive-through mentioned there as well by planning board special permit wherever it's available. And then rental stations, as differentiated, are from a leasing premises or sale premises. Rental stations tend to be shorter term. Obviously, sales of motor vehicles, new or used, would require a license from the select board as well. Under miscellaneous commercial uses, adult entertainment establishments are allowed only in one district. I made several amendments to bring this into a position where it would be deemed constitutional by a reviewing court, and I'll explain it when we get to section 7.2. And then these other miscellaneous establishments just sort of come in here. They're not really retail or office or any of the other things. They're more one of a kind. And these regulations pretty much exist as in your bylaw today. Note that registered marijuana is regulated within section 9.4, which is an overlay district, but we added it to the table. And lastly, accessory uses.
I'd like to go over that.
I'm sorry, industrial first. Trying to think of what we added here. Not much. Self-storage, I believe, was added, and that's about it.
Okay, so I got comments.
Yeah.
And then let me just finish this accessory section. This is what you have today: home craftsman, home occupation, professional offices, custom work in the home, adult daycare we've mentioned already, and these two accessory uses are mentioned in chapter 48, section 3. Without any further regulation, they're both allowed, but a small family child care home is up to 6 children, including resident children, and a large is up to 10 children, including resident children. So most of the towns I've worked with have felt that if your neighbor's going to add 10 kids to the side yard that you share on a daily basis, you probably want to have a public hearing and a special permit just to make sure it doesn't get too wild.
Understood. So I think we had a comment from the board, and we also have a resident who's looking to make a comment. So Steve, I think you were looking at the...
Yeah, a couple. The miscellaneous commercial table, I completely disagree with. I've said it over and over. All those uses were placed in categories where they belonged prior to this update, and they've been rebunched into a miscellaneous category. It's very cluttered and unorganized. I don't like them where they are. They looked better before this situation.
I was going to ask that, Paul. I thought we had other reorganization of the items.
This
Not
is
necessarily changing the yeses or nos, but just putting them in different categories. So I'm wondering where,
We had that.
if there's a different document that should be reflected here.
Right, we've gone through multiple versions of this, and we certainly at one point did get rid of that miscellaneous, so we'll...
At the end of this meeting,
session.
At the end of this meeting, I'd like to put my list on the screen again, for people to see what the alternative is.
Yeah. No, I think we're not...
It's the same
I
stuff, but
agree.
reorganized.
Yeah.
And I've been asking for this for months and months, and the problems have not been corrected. So I would like to at least let people see what mine looks like.
I understand, Steve.
Okay.
No, I think, the headings that I'm looking at don't seem to match what we reviewed at our last session a few weeks ago. So, whatever we need to do to get that aligned to what the board reviewed last time is what we should be doing.
Right, okay.
Then self-storage facilities. We've sort of discussed whether it should be its own category or not. We just approved one as a warehouse and sort of loosely agreed that it belongs in that category anyways. We don't need a new category, but regardless, we don't need to create a new category that allows self-storage facilities by right through our entire village commercial zone. I'm not changing that.
Okay. And that's in industrial use, correct?
Yes.
So that is a new,
That's a new use, new definition, and a new privilege. It's not happening.
okay. And
We already approved it like 2 months ago.
no, I know, yeah. I'm trying to, so in self-storage facility, if that's new, just to highlight that,
It would just match.
I would put that as something for the board to discuss as a one-off at our next session, if we can note that down. Just in terms of what is a yes, what is a planning board approval. And Mr. Siegel, did you have specific comments that you wanted to ask the board here?
Yes, if I may. Oren Siegel, 28 Cotting Road. One clarification, you mentioned mobile homes. It currently is listed as temporary. Have you agreed to go back to temporary?
We agreed that the wording would allow for temporary or permanent mobile homes by special permit.
Okay, I have a problem with that. I understand temporary, but my understanding is to allow on an 80,000 square foot lot, a mobile home, basically to replace a brick and mortar home. I don't know what the taxes would be on a single family mobile home as opposed to anything that was built, but I'm assuming it would be significantly different. And also, if you're not looking for having a mobile park, I mean, temporarily, I understand why you're building, or if it's during the summer, you need to have it currently available. Those are all appropriate uses, but to substitute a single-family house or a duplex house for a mobile home seems to be just contrary to everything that we're looking to do in this town.
It's not a substitution. I'm not taking a house down to build a mobile home. But some people can't afford $300,000, $500,000, $800,000 to build a home.
Well, then maybe they don't look at an 80,000 square foot lot. That's just inappropriate for that position. And if I own an 80,000 square foot lot and I built that house that you're talking about, I wouldn't expect to be living next to a mobile home. And I think that's the difference. So I would suggest that we leave it the way it was, for one. The second thing, and this is just a clarification, in number 10 you have senior housing and you have C 8.3. 8.3 basically is, it's the senior housing facility. Senior housing facility is defined to include senior housing, but senior housing is not defined to include senior housing facility. If you want to leave both in, put both in, but I think it's just, when you say C 8.3 relative to senior housing, I'm not sure whether you're intending to include facility or not.
It currently exists as two separate things in our bylaw. I wanted to keep it the same. It got turned into some sort of cluster where they were combined. I brought it up in a previous meeting that they don't match. I agree with you.
Okay, I'm just saying either put them both in, or at least the facility by definition includes senior housing. So either way you do it, but right now it's confusing because when you look at 8.3, it doesn't really match with.
It was separated where it was like senior communities, like 55 and up communities, and then there was a separate definition for internment, where like somebody would be at a hospital, nursing home. Those were separate facilities originally, yes.
Okay, however you do it, but I just thought that was questionable. The other question I had was on small-scale indoor facilities. Currently, it doesn't exist. Small-scale indoor facilities.
Small scale indoor recreation.
Indoor recreational, correct. And basically, that could be anything.
That does exist in our bylaw right now.
No, where?
It's in our uses table already.
It's in there but not allowed in residential.
No, that was something suggested by the board. It
Okay,
is
and I'm just saying, right
debatable,
now,
but yeah,
there's no limitation on size.
I
So you
noticed
can-
that.
You can put in, I mean, I have grandchildren, I go to their facilities every weekend, and basically the parking is crazy. And yeah, you have a 10,000 special permit, but in order to operate those facilities, it would not exist. And for any of these residential houses to be next to an ongoing major commercial activity is something I think this board should not approve. Right now, it's not allowed, and to do it by special permit does not help at all, because there's no restriction. You can't say you can't have a 100,000 square foot facility with people there, and the numbers are crazy. So I would recommend that you go back to leaving it as not allowed in residential areas.
I can
Thank you for
fill
your
that
comments.
out, but I agree that I noticed that there was no scale presented. It says small scale, but there's no number, so.
And the last thing was, another thing was you've added a new category of brewery and winery. Now, I don't know if Mark is suggesting that that's now required because of its, I can see a vineyard, but you're asking for brewery or winery. That's an ongoing business. That's trucks going in and out in a residential area, and I don't know why you want to start introducing commercial property in the middle of a residential area.
Brewery and winery should probably not go in a residential area. It is an allowed privilege if you're doing agriculture. So if it was, we don't need to specifically say it, but if somebody's running a vineyard, then they could do it on their vineyard as part of their farm enterprise. We don't have to,
It's an accessory use as opposed to a primary use.
yes.
And then the last comment I had was, you changed the dog kennel to adding dog daycare. And I know this is in our bylaw, it's in it for the 80 acres, and I understand it's there. I just don't understand if you're restricting roosters. I live in a community where my neighbor's yard is maybe 100 feet, 150 feet, and a building between me and them. And when they have their dog in their yard, I hear it. And basically, from my understanding, a dog run, which would be just fencing, is not a structure. I don't even know if it would show up in a site plan. But to have an 80,000 square foot lot and have a dog run or a dog kennel facility with dogs running against my property is something I don't think this board should reconsider. I don't know how it got there to begin with, but I understand it's big enough property if you have it in the right spot. But I don't know that, given what you have, you can control where that would be. And that becomes a problem for me.
In our current bylaw, it's currently in the same use as veterinary hospital / kennel. And it is allowed by right in the entire R80.
I understand it for...
The R80 is originally developed as an agricultural area. That's where its primary things are.
And the last thing that I would do is, a lot of these things we've shifted with the protection of a planning board. And I'd ask Mark and even the board, over the last few years, from the town's perspective or from the state's perspective, how many times has a developer brought us to court and we've won in court and not been, basically have to go back and opine to what they've been asking? And whether that's a statewide basis, what's the percentage of successive towns opposing a property on the basis of a special permit that was upheld by the courts? I don't know if there's an answer for Mark, or I'm not aware of one, but maybe this board is aware of that success rate. And that concerns me when we start putting things on the planning board with the expectation that we can really control things, because it's becoming clear that...
I understand your comments.
Okay.
Yes, and that you want to make sure that when we put something as planning board, the planning board is prepared to say no when a project that to projects that it should.
Well, not the planning board. I think the planning board will do that. I'm worried about the town doing that, or council saying, or if Mark can tell us what the success rate is in dealing with the courts. I don't know, but I'm suspecting that it's not very good. So I'm just saying the board needs to take that in consideration when it's looking at things. Just putting a planning board approval on it, if it's something that really shouldn't happen under certain circumstances, they want to define the circumstances, they want to let it happen up front, because if they don't, they may not have the chance of pushing back later on. Thank you.
Thank you.
Chair.
Mark, I don't want to object you, but we do have an updated use table that's in the Zoom link. I did provide you the PDF for it. If you want to check the chat.
Yeah, because of the technological problems we had earlier, I was planning to.
You were gonna drive the session.
I was gonna drive
Yeah,
it.
didn't,
So
yes.
there are, for example, miscellaneous is gone. Mark had to work pretty quickly to get one. We've had a lot of draft revisions on the use table, but and in addition to miscellaneous now being redistributed, that agricultural issue we were talking about, we changed that. So the 5 acre is gone. So I don't know
Okay.
if Mark is able to, I can share it if that's better.
Mark, would you prefer Paul share this quick document?
He's got it teed up, it's probably easier.
Okay. So apologize for anybody who's on the Zoom meeting. You won't see my face for a minute or two, which is probably an improvement. And you just zoom in there, yeah. So again, this is not generally changing the yes, no's in a lot of this table, it's just changing the organization of a lot of it here to put it under different headings. But if you want to scroll up to the beginning there, just go from the top. So residential uses. We have the comment from Mr. Siegel about mobile home, whether we should have that as planning board approved in residential without a temporary note. And then if we continue, this is community facilities. And continuing, open space. And this is where that adjustment to the wording is contained. So if it's qualified as agriculture, it meets the state regulations, so we don't touch it. And then anything else by definition would be under that, so. And then continuing. And this brought those park outdoor uses and dog uses into agriculture. And just continuing to scroll. So we have recreational uses here. And continuing. And the one addition, subtraction here is that the removal of number 4, which is duplicative, which I think I asked to be inserted about 5 years ago, and I'm fine with it dying. I think the initial question is whether people would view an office for a life science company different than the life science manufacturer or something like that, but I think it's covered well, so. And continuing here, we have vehicle-related uses. And this is where, again, some of those additional ones that were in miscellaneous have been added. We've added common driveway, since obviously a driveway is a vehicle-related use, and it is a special permit generally. And then the only remaining miscellaneous uses are the marijuana ones, which have their own table, and then we're in industrial, with some of those additional ones there. So the message center, communications facility has been included in the industrial table.
Those were just moved from miscellaneous, so they're not new.
The overall goal of recodification is to make the bylaw simpler, more effective, and easier to use. So that's the goal here. And keep going. And there we go. Okay. So that is the adjustment there. So if we can just do a version control to make sure that we have that at the next session. Related to the comments from Mr. Siegel, are there any of those that we want to discuss now, or do we want to save those for a separate discussion? I think
I think we're gonna have a separate discussion, and anyways about everything discussed here today, so might as well fold it all in, or.
I was gonna suggest that we hold those for a later session, but definitely taking notes or as we've gone on here. Okay. So I think we can go back to the main document here. And Mark, if you want to share again, Paul is unfortunately putting me back on camera with his computer.
Tim, could I ask one more?
Yes.
Could we review mine? Or is this something are we gonna go over mine at an actual private meeting?
The use table?
Yes.
I believe in the last session, the request was to have that table and your table in a side-by-side.
Okay, so I have mine, it's sent over to Paul. Would we like to review it, or have it as a private session?
Why don't we just save that for our next session, since it's already 8:15 and we're on section 4 here?
Am I gonna get skipped over at the next session?
No.
I've asked several times, I keep getting pushed forward. We're at the end. I will take one more, and we have to sit down and review it.
I understand.
So thank you.
Okay. So dimensional regulations, Mark, I believe you have it. We see your screen again, thank you.
I don't think that there were any changes to the table of dimensional requirements other than a little bit of cleanup of footnotes, so I'm not going to tee that up since it hasn't changed. But the rest of this is pretty much black letter in terms of what's been changed, what hasn't been changed. Sorry, I got a wrong direction there. So general requirements generally come first. This wetlands and waterways section is suspect. Generally, this is now regulated by the Mass Wetlands Protection Act. This would normally be something, that it certainly counts as area, but there are other sections in an overlay district that make it a little bit more difficult. You use this shape factor. I didn't change it. There's an example here of a lot factor calculation.
Yes, I know you wanted us to get rid of it, and we said that it was working and to leave it alone.
Yeah, that's why it's there. And then the rest of this is pretty much what you have today. So I just reordered it. I did not delete or change anything.
Any comments
With
on section 4 here?
With regard to go ahead.
Any comments from section 4 from the board or anybody additionally? And just from a communication standpoint, the zoning board was involved with this process as well as the planning board, and they gave their feedback and comments. Paul, did they have a public hearing on this, or no, was it just us?
Just the planning board.
Okay. So non-conforming.
So non-conforming, one of my favorite topics, is pretty much straightforward. The statute says, as 5.1, bylaw does not apply to structures or uses lawfully in existence or lawfully begun. There's a couple of except clauses in there. If you're going to claim protection under 5.1, then 5.1.1 says you better start construction within 12 months. It used to be 6 months, and the statute was amended, or else you will have to play with the new rules. So the rules are pretty much divisible into 3 categories. One, non-conforming uses, and I'm not talking about anything here having to do yet with single or two-family homes. So a non-conforming use can be changed, or it can be substantially extended, or it can change from one non-conforming use to another, not substantially more detrimental non-conforming use. And all of that is to be done by special permit from the ZBA. Non-conforming structures also may be altered or enlarged by action by the ZBA through special permit. The categories specifically mentioned in the statute are reconstruction, extension, or structural change, or altered to provide for a substantially different purpose, or for the same purpose in a substantially different manner, or to a greater extent. That's not a well-known provision. It's only a couple of reported cases on that. But when something is a non-conforming structure and you're going to change it in accordance with number 2, it does require a separate special permit to do so. 5.4 indicates situations in which a variance versus a special permit is required. This generally has to do with non-conforming structures, not uses. If you've got a non-conforming structure and you're going to do something to it that complies fully with zoning, you still need a special permit. If you're going to do something that exacerbates an existing nonconformity or creates a new nonconformity, it's a variance. That's case law from the Supreme Judicial Court. Non-conforming single and two-family would be the third main category after uses and structures. So what we've done here is create a simplified process by which a non-conforming single or two-family house can be altered by a building permit, provided that the alteration to the structure, I'm looking at 551.1, insufficient area. If the structure is located on a lot that's too small, it's the structure that's non-conforming, not the lot. That's right out of case law. But if the proposed alteration complies with current setback yard, building coverage, and building height requirements, then a building permit can be issued. Same thing in number 2. If the frontage is deficient, it's the structure that's non-conforming, but if the addition complies, front, rear, side, setback, it can be given a building permit. And the last one is the structure is in one side yard, but the alterations will be in another side yard that will be compliant, front, rear, side, building coverage. It also is eligible for a building permit. Go back to the first paragraph. If the structure is not going to increase by more than 100% of gross floor area. So think of it as putting a second floor in a ranch. If none of that is, if none of those apply, or it's going to be expanded by 200%, then the building inspector can pass it along to the ZBA, which by special permit can take action. It doesn't necessarily mean that you can't do it, it just means that we're going to hold a public hearing. I think there was a question that was given to me from Paul today, why did the 25% in the current bylaw change to 100%? My general message to the board when we were doing this is that, there's a lot of, this is a changing area of architecture, of communities. I live in Concord, and it's a pretty typical thing here to have tear downs. So there's a lot of good ideas that you'll see north of 25% and south of 100% in terms of an increase in the gross floor area of the structure, just trying to provide for some opportunities to be creative. Again, there's a special permit at the end of the day if it's too much. Abandonment or non-use. Many towns have added a provision that if you lose your status because there's abandonment, which is subjective. Did you abandon? No. Well, that's the end of the story. Or did you not use it? This is objective for 2 years. That's more of a measurable thing. It's no longer a protected structure or use. So sometimes you'll lose some good stuff along the way, and you can bring it back by special permit. The protective status may be reinvented by the ZBA upon the grant of a special permit. Reconstruction after catastrophe or voluntary demolition speaks more to the trend towards tear downs and reconstruction. So you can tear down any building if you're going to rebuild it in the exact same GFA and on the original foundation. God bless your good luck. If you're going to move the foundation, the footprint, or increase the GFA, you need a special permit. And the Board of Appeals can control this on a case-by-case basis. Once you create a conforming structure, you can't go back. Substandard lots generally it speaks to a question having to do with neighbors swapping land. Such lots shall not be changed unless the change does not result in an increase in an existing nonconformity or a new nonconformity. When I was on my planning board, we had many instances of people coming in proposing to do A&R plans to swap out a triangle or some sort of a piece of property on the side yard. The statute says, without any further clarification, that the nonconformity protection applies only to the situation as it existed on the day it became nonconforming. If you're proposing to change that, you have to have something in the bylaw that would allow it. And then lastly, if part of your property is taken by eminent domain, the remainder will be considered nonconforming. Otherwise, it's too punitive. It doesn't fall into any category. And this gives people an idea of which direction to go.
Okay. Comments around non-conforming structures from the planning board here?
Do changes.
Okay. Thank you, Mark. I think this summarized a lot of what I know the ZBA was looking for with some of the things that they deal with on a regular basis.
Section 6 is general regulation. So you're going to see off-street loading and parking. These are things that apply across the board to virtually every use. There's residential parking requirements. Some of this has been changed to delete references to public, I believe it was senior housing, income qualified housing. All of that today is governed pretty much by Chapter 40.
Since the 70s, you said.
Yeah. Then there's also parking for, this was one of the changes that we made in the last draft, so we'll just take a look at it. Yeah, this gives the building commissioner the opportunity to categorize something which doesn't appear in the chart here below. And in the event an appeal is filed, the applicant will prepare a study provided to the Board of Appeals following the ITE procedures in order to help the building inspector make up his mind.
Building commissioner makes the call. If you don't like it, you appeal to the Board of Appeals.
Right, and you have to give them some concrete information as to why you think you're correct by following the procedures of the ITE. So these are the current requirements. I think we had looked at the possibility of borrowing some standards from Easton, which tend to break it out a little bit more, but we ended up sticking with what you had. And the rest of this is pretty much what's in the parking regulations today. I've moved the provision for special permit relief to the end here. This is new. And it's useful, so you'll see a lot of situations in which the parking is just too much. It overwhelms the need, and you'll have a lot of asphalt that you don't require on a day-to-day basis. So if the applicant for a new construction doesn't think that the parking rules are appropriate, they can ask for a special permit. It will be in the context of the special permit or the site plan approval proceeding, and it'll allow for variance. Let me say that differently. It'll allow the applicant to vary the requirements of this section if it can be demonstrated that it will not result in substantial detriment. And I've added a provision like this to signs as well. You'll see it at the end of signs. And I believe there's a separate section after signs that govern well, there's certainly one that governs performance standards, and then there's a landscaping section that also has the same provision, and a lighting provision, same thing. So lighting regulations and landscaping regulations can also be adjusted, if you will, by a special permit. It's a separate special permit that the applicant would have to file with the authority that's conducting the review. The biggest change to this section on general regulations is regulations which we're calling performance standards. This is a new section. It's an attempt to address some gaps. So the gaps would be in the main headings here. Lighting standards. I think there's one for noise. We have noise standards, 655. Pretty simple common sense things. For example, there is a noise standard in the state DEP regulations. It's 310 CMR 7.10. It says that no sound will be created more than 10 dBA above the ambient. If it does exceed that standard, you can call the DEP. The DEP will take a couple of years to come generally, but a local regulation will allow you to act a little bit quicker. And the typical measurement will be done by the building commissioner. With regard to other major headings here, site design on the location of buildings. There's a whole section on traffic standards that cover everything from mitigation to the section 6.5.7. Mitigation standards are put in place. Regulates driveways, curb cuts, internal circulation. When do you prepare a transportation plan? When do you prepare an access study, traffic impact and access study, a TIAS, which is governed by the standards of the ITE, sections on bicycle improvements. This is something that would guide somebody building something new. And the idea is that when you approve or at least review a new proposal, you're already applying stuff like this with regard to parking and signs. And why not have a broader set of standards that you'd apply to help guide the decision-making process? The most important thing here is that the SPGA or the planning board, whether it's a site plan or a special permit, may waive any of the performance standards where the waiver is not inconsistent. So this is the same special permit mechanism that exists for the parking regulations and the sign regulations. Obviously, some of these things are going to request waivers, and the board would consider waivers on a case-by-case basis. I would say that in the entire recodification of the bylaw, these rules under section 6.5 would be the biggest change.
Thank you. Comments from the board related to those changes here?
Thank you, Mark.
It's good changes.
The other comment is a thank you, so you can pat yourself on the back for that section, Mark.
All right, I've got to go now. Thank you.
Paula Costanza.
All right, section 7 is special regulations. So these are more topical. Earth materials is something that you have today, and I didn't change any of the regs. Section 7.2, I believe, is adult uses. Your adult use today is rather limited in that it really just sets the siting requirements 500 feet from other zoning districts and 500 feet for separation of similar establishments. But the first paragraph explains the changes. So if you're going to regulate adult entertainment, you're regulating indirectly, you're regulating protected speech. The Supreme Court of the United States since the 1970s has said that adult entertainment is protected speech. So you can't say don't do it, because now you're attacking the speech itself, or don't do it in a certain manner. What you can and what's legal to do is the second paragraph, which is that you can, I'm sorry, the first paragraph. You have the purpose here is to mitigate the secondary impacts of adult entertainment, typically property values being decreased by levels of crime, blight resulting from the concentration of uses, business climate. So now you can regulate it. You're not attacking the speech directly. You're attacking the so-called secondary effects. And this is something that's been approved by the U.S. Supreme Court with regard to adults. I put in some mandatory provisions with regard to vegetated buffers. You don't want to have mixed uses where there's an adult use, off-street parking requirements, sign requirements, special permit submittal requirements, and mandatory conditions, and these are contained in the statute. There are certain statutory provisions that restrict the manager to people not yet convicted of these statutes. And you can't have special permits where these laws would be violated as well. So it's pretty straightforward. These are not made up specifically for you. They're provisions that exist across the board in a lot of communities. They've been upheld many times by the state. The only other thing I would call to your attention is that I believe this is only allowed in one district, and the rule, there's a secondary rule for adult entertainment, and that is the municipality must provide a reasonable opportunity for the speech. And a town your size that went through this exercise, they're a little bit, they're probably smaller than you, but Tingsboro up on the New Hampshire line got sued. They had zoned about a dozen or so parcels. I believe that the total acreage or area of the town zoned for adult entertainment was 0.0985, so just under 1%. And the court said that was big enough in a small town. On the other hand, Medford zoned a city block, which was about 1.2 or 3%, and the court said that's not big enough in Medford. So I believe that you probably are okay, but I'm just calling your attention to the obligation to provide an opportunity for the exercise of the speech.
And this is a change, there are some changes. Paul, Mark, you want to scroll up to the beginning of that section. We did change the dimensional restriction from the existing zone. I believe it was formerly 1,000 feet and now it is 500. And the net change of that is that it goes from, there is perhaps one parcel in town where it could be allowed to, there are now perhaps 5 parcels where it could be allowed in the industrial zone.
Probably more like almost a dozen that touch the area, but it's still completely contained within the industrial zone.
That makes a huge difference. Revere got in trouble years ago because the one parcel, I think they said that the building had to have a setback of 200 feet from all lot lines, and there really wasn't a parcel in which that could be done. And T&D Video was the plaintiff. They sued Revere, and the award from the court was more than $500,000. And that's old money. That's not current value. So you have to be careful with this stuff. It's all protected under First Amendment constitutional principles. Wireless communication facilities are generally a protected entity because of the Telecommunications Act of 1996. So we're just trying to follow their rules. Their rules basically are that you can't discriminate between carriers, that you cannot, you basically can't subject these things to anything other than, you have to use a substantial evidence test, which is a stricter test, less deference to the board's decision, more deference to the facility. That's in the federal law. So other than that, your bylaw looks very familiar. I didn't change anything to my knowledge in terms of things like setback requirements and plan submittal. Large-scale ground-mounted solar.
No change.
I think I cautioned the board on a number of occasions that the case law here is still developing at the state level. I repeated what you already had. I'll repeat my warning that there's still a ways to go in terms of the work of the courts to make a final judgment as to what's legal and what's not legal. The legislature wrote that solar energy provision back in the 70s, and they could have followed the same language that we use for schools and religious institutions and child care facilities, but they didn't. They used different language, and that's the source of the problem.
There's no changes to our existing bylaws here at our request and your advice. We didn't touch it.
Right. I'm doing a couple of other towns right now, and I've told them the same thing. My opinion at the end of the day, for what it's worth, is that certainly a system which puts everything on site plan approval would be deemed legal by the court. That was the suggestion of Judge Spicer in the Waltham case. But, you know, that's a big step, a leap forward in terms of the industry. And I don't know that municipalities want to be that liberal that they would just impose site plan approval. So we've got some exploration yet to do in terms of what if anything is legal prior to that. But I didn't change yours, so that takes us to the special residential regulations.
And this was another area for special, was this about section 7 or section 8? Section 7?
8.
Yeah. Sorry, we have a member in the audience who wanted to speak on section 7 before you get going.
Okay.
Orin Siegel, 28 Cotting Road. I'm looking at 7.1. I understand you took out the operation will not decrease the value of adjacent property. And you've explained why that's appropriate. But it also goes on to look at the value of the existing property shouldn't be changed. My concern in looking through this, there's nothing that gives the board power to evaluate its impact on abutters. I don't care about valuation, but is there some way of putting it that the work being done on their side will not negatively impact the abutting land? Getting something in here for the planning board to look to be able to, when they're looking over a plan, if they see that something's going to happen to the abutting land, they... Pardon?
Keep going, Orin. Sorry.
Just if there's something like it can't negatively impact the abutting land, I just didn't see anything in here that calls out they're looking to consider what happens on
your TV is.
Peter, we can hear you. You're not muted, so just if you
Oh boy.
Let me just call your attention, Speaker, to section 10.5, which is the generic special permit language. And the generic special permit language says that when a special permit application is considered, even one for earth removal, the board should consider the following things. Whether or not this is something that is going to provide a social, economic, or community need, whether or not traffic, including parking and loading, will be detrimental, whether or not it fits into your utility system, what it's going to do to the neighborhood character, and what it's going to do to the environment. And then the environment would include everything from noise, lights, dust, odor, vibration. So all of these things would be measured by the special permit granting authority in looking at an application, not just for earth removal, for a widget factory, for, you know, any other thing that requires a special permit in the use table.
But all those would be looking at the premises that they're evaluating and not necessarily enable them to look at the impact on abutting property in this particular case.
I don't see why you think that. I mean, typically on a special permit application, in my experience, the applicant comes in with experts and puts his best foot forward, and the board is entitled to engage peer review experts who would look at the applicant's work and criticize it, accept it, make recommendations. So all of it is heavily evaluated.
Okay, I don't find anything on that list that goes to the question of raising. The impact on a natural environment is a general one, and basically it doesn't necessarily impact a specific abutter directly in terms of how that might impact his land. It's not necessarily the natural environment. That's my suggestion. Thank you.
These are the criteria that were used to evaluate the special permit application of Legacy Place in Dedham over 18 months of public hearing process. I was the board's lawyer. They work really well. And they're broad deliberately to allow the board to go into areas of things like architecture, where they, you know, we don't have to list it. That has to do with neighborhood character. The impacts on the natural environment, as I said, include noise, dust, odor, vibration, traffic, includes parking. So we actually had parking professionals, Walker Group, which is a national parking consultant, came in and testified at a couple of meetings about shared parking in Legacy Place and, you know, where employees would park versus shoppers, how all that would change over the course of a day between restaurants and retail. All of that was presented to the board.
this to the board to consider if there's something that we want to add. For example, if we wanted to adjust number 5 to say impacts on the natural environment and potential impact on abutting properties. That's something that we could add, and I think that wouldn't get us into too much trouble if we tried to do that. Unless you feel differently, Mr. Bobrowski.
Yeah, why don't I put it in terms of, well, I'll make a new number 6, if that's okay.
I like the fact you used potential in that wording.
Thank you, Rob.
I thought that, including that word, said it well. Made it a good statement.
Even a blind squirrel finds it out once in a while.
Oh, 2 or 3.
Yeah. So, anybody on the board have objections to including that in our criteria for a special permit?
No, it's good.
With your permission, I'll go back up to,
The start of
Section
number
8.
8, yeah.
okay.
I think we're at 8.0, so I don't think we're quite all the way up there yet.
I'm sorry, sometimes, let's say, here we go. So the first section here is on affordable housing. If I recall, your original provision had included subdivisions in the language.
You flatly told us it was illegal, yes.
Yeah, so we corrected that, and now it would apply to a multi-unit development in a multifamily dwelling context, but not to subdivisions which cannot be put on a special permit. That's the holding of the court. So other than that, this is unchanged, and it still is a good tool where somebody is building a multifamily building.
And then
The residential cluster development provision is your way to encourage alternative development style, and instead of a conventional subdivision. This is unchanged. I don't
this
know
is
that you're
another one
having.
you suggested to get rid of, and we said we use it, leave it alone. Yeah.
Yeah. Senior housing addresses a need for people to age in place. So what this promotes is various types of senior housing, from independent living units to assisted living units to nursing care units, memory facilities, either standalone or together. And if they're together, they're typically done in the context of a continuing community, continuing care retirement community, which is regulated by the state under a statute. But there are freestanding assisted living facilities. The difference primarily is that CCRC, you sign a contract with the CCRC, and when your money runs out, you're probably going to be carried along on Medicaid. The facility will allow you to stay, even though that represents a deficit for them. If you're in a freestanding assisted living home that's not affiliated with a CCRC, you may be forced to relocate at the end of your money. But all of them are good in the sense that they provide care for people who need it, and the regulations are pretty simple. There's some definitions in the back that tie all of this together. This new provision on accessory dwelling units was something that the governor rushed through in the last summer, and we've now followed the prescription that she had for how these are to be regulated. Your old bylaw had some things that didn't comport. For example, 750 square feet, it's 900 or 50% of the principal unit. You had something with regard to,
Yeah. I mean, it's
the
the core
owner of
what
the property.
Yeah.
Owner occupied is not in the statute today either, so.
Yeah, it's the core of what recodification should be. We wrote our laws, and then the state changed the laws, so we're bringing our bylaws into compliance with the new regulations. Even though they
Right,
came
and
in midstream in this process, it still works.
I had urged Paul, and you still have time to take advantage of this, I had urged Paul to send the draft for 8.3 or whatever that was to Margaret Hurley at the Attorney General's office. She wrote a letter out to a lot of consultants, and she said if the towns are interested in us looking at this before it goes to town meeting, we're more than happy to give you some advice. So I think you'll have better luck at getting Margaret to respond. So if you want to send it to her, Paul knows how to do that.
Thank you. Paul, is that something that you've done already, or looking for the board's?
I'll be doing it tomorrow morning.
Thank you.
All right, is there anything else on 8?
Okay, I'm seeing nothing.
Okay, floodplain, I was given a new floodplain model and I basically recodified it. So this is what I was provided and I didn't change anything. All the overlay districts are together in section 9. The next one coming down the pike here is the one that is, this is your second very common overlay district for water resources. This follows the model that DEP put out. They put out a couple of versions of the same thing over the last 20 years. Yours is entirely consistent with what DEP recommended, and I didn't change anything. Now there is in the DEP water resource model a provision that says if you don't agree with the delineations of the districts, then here's how you solve the problem. Remember that a water resource district typically follows the resource. So the difference between Zone 1, which is owned by the water provider, Zone 2, which is the sand and gravel deposit surrounding the well, and Zone 3, which is the till up to the watershed divide, is a resource boundary, it's not a line on a map. So if the boundary in relation to a particular parcel is in doubt, result of disputes will be determined by the planning board after an application for a special permit. Any application shall be accompanied by adequate documentation. Burden of proof's on the owner. You're going to see this again in the next district. I just call it to your attention because it's one of the things that was in yellow as we passed this from draft 7 to draft 8. And that's the regulations for your wetland protection overlay district. This has been the subject of a couple of conversations between me and you over the course of the recodification. I noted there's no map of this district today. It's a long 2 or 3 page scroll. Then the land located at Smith Street bounded by. In some cases, those wetland descriptions may no longer apply. The wetland might have gotten bigger, the wetland might have gotten smaller. So we borrowed the district boundary dispute language from the water resource district and put it into the to the wetland protection overlay district. That solves one problem, but I think just to
There's a
go on
larger
record.
problem there that we've discussed, yes.
Right,
And that
okay,
the
so that's,
map does not have a map, yes.
right. And I know that there's been conversations with the Conservation Commission about this. Here's the long boundary section I was just alluding to. And then the last one is marijuana treatment center, marijuana overlay district. And this allows for so-called RMDs, but it doesn't, which is medical, but it doesn't, it doesn't allow for adult use. And I didn't change any of the regulations.
That was
So
gone
that's-
through a lot of work over the past few years, so, yeah.
Yeah. So if there's nothing on, anything in section 9, I'll stop for a minute. Oh, I'm sorry, there were a couple of districts that had extensive design standards that I thought were more appropriate to put in separate sections, special rules for special districts. So the VC district has its own design rules. Those are repeated here. And more importantly, design in the Village Center Core District has a substantially longer set of design standards that seemed appropriate to put into a special rules section, and here they are.
Yeah, that's what we had a grant, and somebody had all sorts of time to come up with these, so. We have one comment from Steve, did you want to just?
Yeah. 9.5, the village commercial design standards. But we have a lot of standards that aren't generally followed or enforceable. They're considered guidelines. So I redrafted it, I sent a copy of it over. But essentially it's changing the word should to shall in most of those sentences. And then it gives us teeth.
I see should right there, so you want, does that occur in both 9.5 and 9.6?
No, the village center core is really done, well done, but the village commercial district needs more teeth, so.
So.
I can send the whole document, I have it with Paul,
But the broad strokes is should to shall.
Yeah, so that all the
I
standards.
can just do a word search. If everybody agrees with that, I'll do a word search and change should to shall.
Now, I guess from a design standard and regulation standpoint, Paul, if we're saying you shall do this, if for whatever reason it doesn't make sense in village commercial for the building use or anything like that, is that something that we'd be asking the applicant to get a waiver on? Is that something from a design standard standpoint?
Well, unless you have the ability.
Maybe I should just take this language that introduces design in the village center core, take a look at where my cursor is, and put it at the start of 9.5 too.
That's what I did on my document. If I could send you the document, I think it lays it out almost exactly.
Well, whatever way you want to solve this is fine with me, so.
Okay. Let me see. So, I guess from the board's perspective, do we want to put more teeth into that 9.5 around village commercial? In terms of, if you scroll up to the start of 9.5, Mark, where we're talking about this, the placement of the building versus the placement of the parking. So the building should close the road and sidewalk to encourage traffic. So those kinds, all of that.
Guideline, the use of the word guidelines is not regulatory, it's policy.
Right, exactly. So.
I also, in the document I had, made an exception for single-family homes so that the guidelines would not be enforceable on a single-family home.
Understood. So, from the board's perspective, do we feel comfortable making those more mandatory across the board, or is that something that we'd want to review Steve's language in detail? In terms of, I like this one being shall, this one's a little bit harsh. If we make it shall, I would like this one to be should.
It wasn't a blanket change, so I would like the review.
Okay.
It wasn't every single sentence.
Okay. Was that something, Paul, can you share that to me, since I know you're running the laptop, or Steve, if you can send that to me, I'll pull that up in a share. And we can just dive into that in terms of adjusting that. I knew I logged into the Zoom meeting for a reason tonight.
You put your email in?
So it is sending, and as soon as the internet decides to work, I'll pull this up and we can review that directly. So Mark, I'm going to steal the screen from you in a second here, so
Great, I'll stop sharing.
it's not here yet, so the Norton email server is running a little bit slow. Hold on. I can only refresh it so many times.
Hi everyone, how y'all doing?
Hi Peter, how are you?
Well,
day.
good.
We almost,
Watching the meeting while getting ready for the 10 o'clock news.
we almost missed you tonight, Peter, so thanks for joining. So let me pull this down here and I will share. This is Steve's adjusted wording here for the village commercial standards here. And let me know, can everybody, yeah, that's coming across okay.
Alright, so
On my
that,
monitor, there's a whole bunch of different windows on top of it here, so it comes across clear on the Zoom, so that's okay.
that's the original with the words should just highlighted so you can see where we're working with the start
They're
with.
italicized, yeah.
Yeah.
And then in the updated, so again, this is borrowing the introductory language, so guidelines, where it says shall, you have to, and you need a permit from the board. Where it says should, it's a guideline, and it's a strong preference for the town. So,
Yeah, that's consistent with
the other one here.
the next district, yeah.
Yeah. So, we have shall for all of these sentences, and they're broken out by numbering. For roof lines, we have a should there for mansard and A-frame roofs. Non-roofing materials. Garish roof colors, that is,
It's an old-fashioned word.
okay. We have signs. Most of these are should, except for internally illuminated ones that shall be whole panels that are lit, and shall be located so light is directed only onto the sign facade. Windows would be shall provide an appropriate portion of the facade to provide a view to the interior. Awnings shall be designed as a part of the facade.
And then that's from the original, and then there's 3 segments that I took from the VCC that if we feel could be added, that'd be good. If not, not a problem.
And are these the 3 here?
Those are the 3 that are from Village Center Core.
Okay. So in village commercial, we're at base, the suggestion is to make it easier for pedestrians and bicycle access. Don't put travel lanes in the frontage parking or travel lanes in the frontage area, except where driveways are approved. Separate parking spaces from walkways. Outdoor seating, landscape features, street trees. Would the street tree requirement, no, I guess it would override the general landscaping requirement if it was here.
If it's a shall or standard, it does.
Right, but I know we already have a landscape tree requirement, so this would basically supersede that.
Right, if it's in village commercial.
And then we have pedestrian walkways, walkways that cross traffic, bicycle parking, and building entranceways again, which are from the village center core. So I'll go back up to these design standards here. From the board's perspective, are any of these that we see listed as shall, rather than the previous kind of should, or just in terms of a guideline, not necessarily being binding? Are there any of these that we think shall is too far, any that we think shall is appropriate. And if you'd like to take some time, look at this and think on it separately.
I like to read it side by side on my own, but I generally don't have a problem with it at all.
The shell is good.
Okay. Anyone else? In terms
I'll point out one thing, drive-through generally shall. Doesn't that kind of undermine the shall when you put the word generally there?
Generally has a strike through.
It used to say generally should. I scratched out generally.
Yeah.
Oh, okay.
There's a strike through on that.
Right, yeah. Well, I must be 66 or something. I didn't see the difference in the font there.
No worries.
Sorry.
Yeah, yeah, I'd definitely like to take some time to, make comparisons.
Okay.
Cool.
Paulina, you have this, I have it. Can you just make a note to make sure that the board has this for side by side there? I'll stop sharing here now, Mark.
Okay. If, Paul, you'll send me a copy, I can massage it and put it into the recodified bylaw.
Okay.
And then,
So we were in section 9. Anything else on section 9?
yeah. Okay. I would just ask, whether or not those shalls also create the need for some sort of relief in the event that it's just a little bit too much or a little too strict for a specific building. Shall means you shall do it, but that's every time. So you might want to say that a standard can be modified where the applicant shows that some alternative would do the job.
Yeah.
That'd be great.
The suggested wording does include that intro paragraph from 9.6 where it says you get a waiver if you want to not follow it. It doesn't necessarily provide criteria for that waiver, which obviously the default would be the board thought it was a good idea, but.
I probably will borrow the waiver provision from section 6.5, which is pretty much the same idea.
That's fine.
Okay, so now we're going to section 10. Section 10 is largely everybody's job description. So the first job description here is that of the building department, building commissioner. And we start off with administration. Building commissioner is in charge. Here are his duties taken from your old bylaw. Building permit is required for any new construction. Certificate of occupancy is required in order to occupy the building. There's a couple of special rules here for the VCC district. We just repeated them. Those are changeovers from inspector of buildings to building commissioner. Under enforcement and penalties, we've added a provision for an enforcement request, which is in the statute. Somebody can write him a letter saying, please enforce. He's got 14 days to respond. Courts are more forgiving than that. You don't have to respond within 14 days. If you're busy, the courts will forgive it. But generally speaking, if you write an enforcement request and the building inspector doesn't respond, you really can't go forward to the Zoning Board of Appeals. I've actually had to sue a building commissioner a couple of times in mandamus to compel the word no scrawled on letterhead. But that gives me something to appeal, right? $300 is the penalty, each day a separate offense. Non-criminal disposition is a parking ticket, and there's nothing magical about 100 for the first, 200 for the second, 300 for the third. Those numbers can change. Zoning Board of Appeals, powers are listed here, and it's all statutory. No variances for use can be issued. That was a choice that we made early in the game. If the ZBA gets a provision for its powers, the planning board should also. So this is a new section for planning board. Special permits are in your jurisdiction, and site plan approval is in your jurisdiction as well. Special permits, here is the language I pointed out before. These are the criteria to help you make your decision. Here are some model conditions that you have, and I've added post-surety in the form of cash. This was something requested of me. There's a procedure here for referral to other boards so that they can weigh in. The lapse provision is now 24 months, but it can go to 36 months. But you'd have to change this at town meeting.
Or if the state passes a rule that says you have to give special timing to everybody in a certain time period like we're under right now.
Yeah. Site plan approval has been preserved. Most of your language is the same. The one thing I did do that is new is I added a provision here for appeal. The appeal now, after the town meeting, will go directly to a court of competent jurisdiction. I think your appeal provision now may not include that. If you're going to go directly to court, the land court has suggested that a public hearing is required and that a record be produced so that the court can look at something. So I added a requirement for a public hearing to please Judge Foster, who wrote the land court decision. I think it's a good idea, and that's now included here as well.
Thank you.
And then lastly, on the Section 10 procedures, I added two new provisions. One is site plan review for Dover Amendment uses. Dover Amendment, again, is uses B1, B2, and B3 in the table. That's churches, schools, and childcare facilities. These are uses which there is case law that says you can't subject these things to site plan review, but in a case called Jewish Cemetery Association versus Wayland, Judge Sands of the Land Court said if you keep it simple and the site plan review process is used to verify eligibility and to impose the requirements listed in the statute, that is reasonable regulations regarding parking, loading, dimensional requirements, and it's limited to that, you can subject them to site plan review. And I think this is a much more fair way to do it. If it's got to go to the building commissioner, you're putting the man out on a cliff, and it's probably a controversial decision, at least in some cases. Churches, schools, and childcare facilities are among our more controversial decisions. This sends it directly to the planning board. The planning board, first of all, verifies eligibility, and then second, looks at the reasonable regulations that are in the statute, bulk and height, yard size, lot area, and then they impose conditions. That's by majority vote, not supermajority. If you don't like what the building commissioner said, it goes to the Board of Appeals, and that's a supermajority decision. So all of this makes a lot of sense from the perspective of judicial economy and wise decision making. And then the last thing I added was a request for reasonable accommodation. This has to do with facilities protected by federal disability laws, including the ADA and the Federal Fair Housing Act amendments as well. If a facility for recovering drug and alcohol abusers comes forth, it's a special category. It's very tricky. You need to call your lawyer immediately. That's the message here. And do it the right way. Because if you don't do it the right way, there's certainly penalties that will be imposed by a reviewing court.
Not nice ones.
We'd have the Dover thing come through here.
Okay. And then lastly, definitions. At section 11, what was pretty straightforward before, I'm on page 122. You now have that's 26 pages of definitions.
Are there any specific definitions that we wanted to touch on?
Yeah, I got a couple actually. I do find that there's a couple inconsistencies or sort of vague wording, I guess, in the commercial recreation facilities definitions. There's some overlap of where things go on, like, based on what setting. Bowling alley is written on 2 or 3 different ones. There's a marina, which we don't need a marina setting. There's like,
We could build one on the rest.
there's like a game preserve for hunting, which like, that would be,
But
that would fall under a club anyways. It's not even
Yeah, that would be a challenge.
a sports club, which already falls under the health and recreational club category. Like, there's sort of some rewording that needs to go there.
Okay.
That might take slightly more than a second. But that's if we want to get into that now.
Are there specific, I know this is all organized by alphabetical order. Is there a couple that you wanted to call out where you said bowling's in a couple? I see commercial right there, you got it up there, perfect.
Well, we have, based on the definitions, it's on,
Yeah.
there's sort of some mixed stuff, that's all. Because we also have small scale indoor recreation, and that doesn't actually have a scale.
Yes.
And then we have recreational facilities, like, already in our bylaw for, like, baseball fields and so do skating rinks fall in the commercial recreation outdoor facility, or is it a recreation thing? Is it like, there's a lot of variable. Is it a small scale indoor recreation, or is it larger scale? There's a few anomalies that need to be corrected, that's all.
But they're all centered around those commercial recreational facility, indoor commercial recreational facility, outdoor, and general recreation facility.
Pretty much. And then there's the personal services. Well, right now we have it as personal, general, or trade service establishment, which covers anything from a barber shop to a plumber, a blacksmith. We had talked about dividing up those categories. We have service and repair shops that we remove from the table. But in our definitions, we have definitions separately for personal services, for trade services, and for repair shops, all separately. I was suggesting that we do personal service establishment, and then as another use, trade service and repair shops, which are more in line together. So trade services like set up areas for carpenters and all that. That's not really a salon.
The suggestion is to have 2 lines in the uses table to match the 2 definitions, not necessarily delineating differences in the use table.
Yeah, without any change to where they're allowed, but separating those uses for future adjustments.
Okay.
And then there was one more thing that was in small scale recreation, which is like art studios, voice classes, concert halls and theaters and stuff. I'm not sure, but I put it into its own category. It was like studio and exhibition space.
Okay.
I didn't hear that last one, Mr. Chairman. Which was that?
It's for the small scale, so you're almost there. There's a potential proposal to break out some of those uses into like a studio space kind of definition.
Because we use the word studio several times, and then even in the upcoming MBTA zone, we reference the ability to put in art studios and that, but we don't have it in our table specifically.
Okay.
So there's that section, and then there's one more that's kind of important. Definition-wise, for top-of-the-shop dwelling and mixed-use dwellings, or developments rather. I wanted to add the line to both of those that says, uses within top-of-the-shop or mixed-use developments shall be limited to only the allowed uses, or allowed as of right or special permit uses as prescribed by the zoning district the development resides, and shall not include any use not permitted in such district.
Okay, so it's not under the dwelling definition. It is under the commercial top of the shop definition.
Yeah.
So Mark, I think you tried to scroll to it, but not quite it's looking for the commercial top of the shop definition here.
Oh, it's a different definition than the one I've got?
I'm assuming that says just dwelling top of the shop.
Yeah.
I'm assuming there's
Is
a
there-
different
I
one
think that's
for-
the only.
No, that's the only one. That's what I
Okay.
want to put.
Okay, so you were at the right spot, and I apologize.
Okay.
So
I had brought up in the last meeting that top of the shop development should only allow the type of housing that's allowed in that district as the dwelling on top. If the zoning code says that a single family is not allowed on top of the shop in a commercial zone, only multifamilies are allowed, then a single family shouldn't be allowed to be built there. If it says, if you do a top of the shop in a single family zone and multifamilies are not allowed, multifamilies should not be allowed in that top of the shop. Where right now, if it's any type of housing can be built on top, then it supersedes
right.
what's in our district.
What if there was a building which just had one apartment on top? That would in theory be a single family.
If single family is allowed in that district, then it should be allowed on top.
Okay. Yeah, I know we discussed this as it tied into the MBTA regs as well. Okay. I think the different recreation definitions, it may be helpful to see them all lined up
Sure.
next to each other.
Yep.
And then we go, okay, let's delineate the three of them and make sure that we don't have the same thing in different ones. Or if we do, that we're providing justification for it, where it's, this is a tiny one of these and this is a big one of these.
Would you like me to send you my version again? Or
Yes. I know with the trade services and general services, that was something where I think at our last session, that was another thing that I was expecting to have the side by side with what was there and what you had with, and what Laura had put together. So that's, I think, what I was expecting us to be able to review is A versus B.
okay. When you bring it up, there's one other thing on there too that I put in that we sort of touched on, but then got away from. So I put in neighborhood shop, which would be like a small scale shop and with an actual scale attached to it. And we gotta see how we feel about that. We mentioned about having small shops or neighborhood type shops, but being able to keep them very, very small.
Okay.
Yes, it's on the bottom 2 pages of that document.
So Mark, I'm going to steal the screen again, so apologies in advance here. Let me see. Okay, can everybody see this? Just to make sure. I'll just zoom in here.
This is all stuff we decided on already.
No, that's fine.
Page 5 and 6.
Okay. So there we go. Covered that.
There we go.
So this is the suggested addition for dwelling and mixed-use development. Again, basically saying uses within these developments should be limited to what is allowed in the zoning district and doesn't give you free rein to build whatever you want just because you're putting it on top of a commercial development. Any objections from that, from the board here?
Would we have to keep it consistent with the overlay district, like you just mentioned? Like when you have the overlay?
The overlay would be a separate set of conditions that you're choosing to use as opposed to the bylaw
But I'm saying,
regulations for the underlying district.
my question was wrong, my statement was wrong. Should we keep that consistent when we're doing the overlay, like Steve just said? If we're gonna do it, if we're gonna say we're gonna go to the underlying, shouldn't we go to the underlying in the overlay
What do you-
also?
we could add the same wording into,
Yes, that's
into
what
the
I'm saying.
MBTA overlay.
Yes.
Yes, we could do that.
Yeah.
So that's outside of this.
Correct, yes. I'm
but-
just saying that keeping it,
Yes.
if we're gonna change it to the underlying, I think we should keep it consistent.
Well, I don't think it, does it say underlying or just any district, the district it resides?
So the
Same
one
thing.
that is.
So it
Same
could be
thing.
any district that was in, over or under, I suppose.
So, objections to adding these to these two definitions? I'm not seeing any, so I think we can move forward and add those. And then these are some of those discussions that we had about the recreation here.
I apologize for not having a side-by-side wording.
No, it's okay, I think. So the indoor recreation and recreational facilities. So this is short compared to what is there already, correct? So you've eliminated some of those
It's,
not relevant uses?
yeah, it's rearranged and worded more appropriately, to essentially just reflect that it's a smaller place, not an entire large sports facility generally. It's more of a, it still doesn't have a scale applied, so,
Okay.
but it's more about what's inside. But again, a side-by-side comparison of definitions would help a lot.
Let me see here if I can, I'm gonna stop sharing and share again here. Let's see if I can pull this off without making a fool of myself technology-wise. Yeah, that's not gonna fit. Okay, I tried. That's gonna get too small. So I will just go back here.
We also have a definition for general service establishment too, which also includes builder and it's just the same as a trade service essentially, which starts blurring the lines a lot.
Okay, but the recreation discussion is adding some clarification and adjustments to what we're including in those definitions. And then these three are creating some delineations between personal service, trade service, and we'll call it studio. I think I would want to look at studio a little bit.
Mm-hmm.
It is village commercial and above only. I think I would want to think on that a little bit more because studios defined in this way could have a whole lot of different scales.
Sure. Well, the gray words underneath art studio, drama voice, dance, concert hall, theater, that was all under in small scale indoor recreation.
Right.
So it's not a new definition. It's just separation.
Yeah. Are the use table entries the same as small scale indoor recreation, or are they suggested to be different?
For what?
For what you're proposing as the studio use?
Same.
They're the same?
Well, not in the residential zone.
Right. Do the existing regulations allow it in the residential zone?
No.
Okay. So, with these, do people want to look at them further, move on them this evening?
Well, if you would send them to me regardless of whether it's approved this evening, that'd be great.
Understood. So, Eric, Alan,
I'd say make it the last thing to review on our next.
okay,
I just have to read it side by side.
Yeah.
I can't.
understood. I tried.
Yeah.
Monitor's only so big.
I did too, like a couple
My eyes
hours.
aren't that good. Okay. Anything else in terms of definitions? Otherwise, I believe we've gone through the bylaw.
I'm done.
I'm gonna hold you to that, Steve.
Well, for now, until you say something.
Okay. So we have a couple of things to get you, Mark, to get ready for our next revision here. So we'll work to do that and look to get this finalized, and we'll see you at town meeting.
Tee it up for May 19th, if I remember correctly.
Yes.
Great, and Paul, I'll be relying on your notes. I've got some notes, we'll compare and we'll go from there.
Okay. Thank you. Okay. Well, I knew that wasn't going to be quick, so.
I thank you all for your attention and your particular care and detail. It helps a lot, so
Yes.
I'll let you get on with your business, and I'm going to tune it out.
Okay.
Thank you.
Thanks.
As mentioned at the opening of the session, the request from town council is to continue what was previously listed as the MBTA zoning discussion. Can we have a motion to that effect?
So moved.
Seconded.
Okay, we have a motion and a second from Alan and Steve. Any further discussion on the motion to continue to April the 8th? Okay, hearing none. Rob, since you're remote, I will go through the roll call here. I'll start in person and then go to you. So Steve?
Aye.
Alan?
Yes.
Eric?
Yes.
Jim?
Yes.
Rob?
Yes.
And I will vote yes. Additionally, at the start, we said that 1 Dean Street was looking for continuance to May 6th. Any objections?
So moved.
Seconded.
Thank you for the motion and the second. Second was Eric, correct?
Correct.
Okay. Any further discussion? Hearing none, I'll go through the roll again. Steve?
Yes.
Alan?
Yes.
Eric?
Yes.
Jim?
Yes.
Rob?
Yes.
And I will vote yes. And we'll do one more continuance, and while they're doing that, I think the applicant for 225 South Worcester Street, if they're here, can come up and start getting set up here. The applicant for 361 Railroad Colony Road is requesting continuance to our next session for April the 1st.
So moved.
Do we have enough time in that meeting? It's getting busy. Just because they asked for April 1st doesn't mean we have to give it to them, correct?
That is correct.
I'm just thinking we continued a bunch of things and it's a joint. I'm just thinking it's adding
Oh,
up.
it's up to the joint. That's right.
One consideration though is your next meeting is April 15th, since we're reserving April 8th for the MBTA. The election's the 26th, although that is a site plan. So, that's 4 votes versus 5. So you might have flexibility on that.
Basically, the guidance from you is if we feel like we can do it in one meeting, we could do it on the 15th. But otherwise, it would be something where we'd have to consider that the board would have turnover.
Correct.
Looking at what we did for 361, do we have concerns about that on the 15th? In doing one and done? Or Paul, do you think that they have the materials ready that the board could reasonably do it?
So they're at conservation as well. They were continued to, the 14th. At
Of April?
Concom.
Yes. So there's no meeting of ours where they would have gotten their input from Concom.
Prior to that, no.
There's nothing.
Keep it on the 1st and we'll probably end up continuing anyway.
I think, why don't we continue to the 1st, and we can ask the applicant
Mhm.
if they're prepared to present on the 15th separately, and we will promise not to put them at the end of a very long meeting.
So moved.
Seconded.
Okay? And I'll go through the roll again. Steve?
Yes.
Alan?
Yes.
Eric?
Yes.
Jim?
Yes.
Rob?
Yes.
And I would vote yes. Okay. Well, without further delay, thought I was calling you up here at the right time, but I was jumped the gun a little bit. So if you want to just give an overview of the project you're proposing for 225 South Worcester Street, and we'll go through that. And I do see we do have the plans shared here above the screen. So
Okay, good evening. My name's Peter Lavoy. I work with D&L Design Group. I am the engineer, and my company's out of Milford, Mass. With me tonight is Ryan Tavalli, who is the applicant. He's in the audience. So, Paul, could you put up the overall presentation plan that I sent you? Yeah. Just that it has color. The plan has color. It's easier to see.
This one's not out.
So, yeah, that one right there. Okay. So, we have an existing project here, which is roughly made up of 5 lots. The total area of the project is roughly 24 acres in size. It goes all the way around like this. Has frontage.
The screen share disappeared.
yep. Hold on. Yeah, the screen share dropped off here. So hold on a second.
Just a sec, Rob.
Thank you for flagging. There we go.
Okay, so the project's located in this location here. The address is 225 South Worcester Street. South Worcester Street runs along the right side of the page. MBTA runs along the top in this location here. And then the intersection of Dean Street and South Worcester is right here, which is 225 feet away.
And that line at the top is the railroad tracks?
And right here, yes, yep, this, it runs right along the top of the parcel. That is the railroad tracks right there. So the overall parcel area is 24 acres in size, roughly. We have a large wetland in this area here, and then we have a small wetland that runs through this location here that ties into the drainage on South Worcester Street. There are 2 vernal pools in this area here on this lot. The lot is basically flat. The elevations go from elevation 93 to elevation 99. So the frontage in this location here would be our access. So we are proposing roughly from this point here all the way to this little cul-de-sac in this location, roughly 1,200 linear feet of roadway. Basically the travel lane will be 24 feet wide, and there will be a sidewalk on one side of the roadway, all the way from the cul-de-sac all the way out to South Worcester Street. And then there is an existing sidewalk that runs along the north side of South Worcester to the tracks, and then they cross over, and the sidewalk's on the opposite side.
It's a pretty weak sidewalk, though.
It is a pretty weak, yes, it's a bituminous sidewalk with no curbing on South Worcester Street. So basically this 1,200 linear foot road will service 15 duplexes. We have 2 duplexes in this location here, and then we have 13 duplexes in and around that area. So there is also an R60 in Village Commercial, and this location right here is the zoning line. So this side of the zone is an R60, and then this area here towards South Worcester Street is a Village Commercial.
I believe that's right behind a couple of small business facilities and then some residential homes, correct?
Correct. So we have, I think this location right here is a pool company, and then these buildings right here are residential. This is a residential right there, and then there is residential in this location here. This is a vacant parcel right there. So in the Village Commercial, this is roughly 5.5 acres in size, And then in the R60, we basically have roughly 18 acres. So we are proposing 11 units in the village commercial and basically 4 units in the R60 district. We will tie town water, so town water runs within South Worcester Street. We're gonna run an 8-inch line coming around, and then we're gonna go through this little grass strip here to create the loop. This was previously approved in 2008, this project. It was just over 55. This is not going to be an over 55. So we are proposing that loop of water. Septic, so basically these 2 units will have their own septic system in this location here, right behind those 2 units. And then the 13 units in this location here will have a shared septic system back here that runs parallel to the train tracks. The septic system is all septic systems are outside the 100-foot buffer, so we are not proposing this system within 100 feet of that wetland, and then these 2 systems are greater than 100 feet as well. Project will have gas and electric. Drainage, I have 1 underground basin in this location here for a small portion of the road, so no runoff from this development will go out into South Worcester Street. I have an open basin in this location here because right here is a high point, so this will be collected by 2 catch basins and discharged into an open basin, and then the rest will come down. There's another 2 catch basins here that will go into a basin in the back of these units. There is another high point here. The rest of this road will go down to the cul-de-sac and then into a little forebay, and then it's connected with a grass swale along the back of this unit and then goes into that basin. I used NOAA 14 to do my stormwater calculations. We also followed stormwater management. There will be no increase in runoff or volume towards the wetlands and towards any of the abutting properties. We do propose a wetland crossing in this location here. We're basically filling 3,200 square feet of wetlands, but we are replicating 4,900 square feet of wetlands. We are in front of the Norton Conservation Commission right now currently. The project has been peer reviewed by the peer reviewer for the Conservation Commission. I was just waiting for comments back from the planning board to make 1 revision, and then I would resubmit my drainage report to the peer reviewer. Proposed open space, we are preserving 66% of the buildable area. So 66% of the upland on this project is being preserved. As you can see, there's upland here that will be preserved, that will not be touched. And then the area around the units, this area here will remain undisturbed. This would be grass area, but the overall open space has 66% of that open space is upland. And that's basically it. Questions that I could answer, I will.
Sure. I was gonna, Paul, from, I know we have your memo available in terms of, just from a background of the project, the specific, obviously this is a special permit, so the specific areas they're asking for special permit relief, and then status of anything else with other departments. You mentioned conservation. I see in open gun fire is in progress. It's kind of a long common driveway. That's kind of something that I always wonder if they're good with the turning radiuses and everything.
Right, so there are 4 special permits they're seeking, so duplex in the village commercial and residential 60, residential cluster development, common driveway, and in the wetland protection district. Plus there's also a site plan needed because there's more than one duplex. Concom was continued to April 14th as well, so there are some peer review comments from Pat Brennan, the peer reviewer. So, yeah, so you'll be making ultimately five
Understood.
motions.
I could,
And in terms of, I mentioned fire, have they looked at have they looked at it and checked off, but they haven't checked the box in OpenGov, or is that open discussion?
They haven't checked, they have not checked the box off on it.
But you're not aware of any other discussions with them about it, or?
I haven't heard of anything with fire.
Okay.
Conservation, they're working on through the peer review issues, but I went through OpenGov today, and other than mine, I didn't see any other department comments.
I have it open here, so that's why I knew the answer when I asked.
Okay, glad I reviewed it.
Okay, but now sometimes it's oh yeah, we reviewed it, he just has to do a final check or something like that, but, okay. Steve, you had a question?
Yeah. So, my first one is cluster development. Cluster developments are not allowed in village commercial. That's my number one. The second is common driveway, which is only allowed to connect up to 4 parcels. So, what is...
4 parcels or 4
Well,
properties?
4 properties.
4 parcels.
But this wouldn't be there's 4 parcels, but this is 1 parcel? So it's
This would be 1 parcel.
So it's not a common driveway, it's only a cluster development. Cluster developments
4 parcels.
But they're all gonna be combined into 1 development in 1 parcel.
Through what mechanism?
Right.
Is this a subdivision or unsubdivision or A&R or?
If I can answer one piece of it, sorry.
Sure.
Ryan Duvalley, Heritage Realty
Sure.
developer. So it's kind of unique because we're dealing with 2 different zones. We have the village commercial and the residential, and we have to adhere to what we're allowed to do in each. So the project, we're trying to keep the project cohesive, not only within itself, but to the residential nature of the area. But the zoning on the residential side, we're applying, that's why we have the special permit for the cluster related to the residential, the duplexes on the residential zone. And then we're using the special permit allowable on the village commercial side for that construction. So this is gonna be 1 condo association. If they ultimately end up 2 parcels, not 1 parcel because of the zoning differential, but that's kind of how we applied the zoning and the way we discussed it in development.
The back parcel, so to say, if there were to be,
Yep.
that would be the one connected with like the trail sort of access area from the road, not an official road, but that little corridor.
Okay.
Is that like the green grass that goes between the housing?
Yeah, that's just a
That's an
20-foot
easement for
Yeah.
water.
How wide is that?
20 feet, I believe.
So you don't have the frontage for a second parcel.
No.
Any parcel connected by a common driveway
Well,
has to
the
have
way
frontage.
this was already a previously approved project, which is all well expired and all that. The way that was done at that time, they did it as, I believe, a subdivision, that the roadway was a typically approved roadway, and that created the frontage for any of the parcels. But the zoning was different at that time, so we have to do it a little bit differently. So again, there's a lot of moving parts, obviously, with the special permits and site plan reviews, and this is kind of how we were advised to put it through. If it needs to be like more of a Form C application, but with the same design, the roadway layout and all that would still be the same, but that's kind of how we're looking at it.
I mean,
Paul, is this,
yeah.
I guess I'm looking for, we're looking at this as cluster, but only on the back half.
But it's not.
And then, but it's,
Clearly not. It's mostly in the village commercial.
Right, and the residential, the few units on the residential side, we're applying the cluster to have the,
The few units on the residential side are not necessarily the problem, it's the rest of the cluster that's not allowed to exist.
which part?
For,
The entire village commercial area.
from a cluster development standpoint.
We're not doing a cluster in the village commercial. We're applying that you're allowed to do a duplex by special permit, and you can have multiple uses on an individual lot. And so we're having multiple duplex uses on a single lot, and as long as we meet the, I believe it's 50% coverage criteria, we can have as many buildings.
So can I ask you this, how many parcels could you fit on there in a typical subdivision? Because that's as many units that you can.
On the residential side, correct?
On the whole thing, because that's how many you could put into a cluster development. No
We're
more.
not doing a cluster on the village commercial piece.
I understand the dichotomy you're trying to say here. For a cluster development, one of the requirements is to show the regular plan.
That's on the residential side, and we did a calculation of how much upland we had and divided that by the required area for a duplex in the upland, and that's how we came up with around 4 units, 4 buildings. That, it's about 4.5, but we're allowing 4 buildings in the residential side. This is how it was done the first time it was approved.
I wasn't on the board.
Correct, I understand. They didn't do it as a cluster, they did a duplex and a triplex actually. We know multifamilies aren't allowed in the residential now, so we're just doing it as duplexes. So on the residential side, 4.5 buildings are allowed. So we've designed it with about 4 buildings. That's for the residential piece. The allowable use on the village commercial is not a cluster. It is a single parcel that has that many duplex structures on it, which is allowed the multiple structures in the village commercial, as long as we don't exceed the coverage criteria, which I believe is 50%, and we're well under that.
What's the space of the village commercial
The
parcel?
spacing is, I know it
Do
adheres
you
to the
need
zoning.
the area, or what are you talking about spacing?
The area of the village commercial
The total
parcel.
area?
So we have,
So,
by my count, I'm saying 11 duplexes in the village commercial,
11, yes.
and that's, how big is that parcel?
That parcel
Or
is
parcels that-
5.5 acres.
Okay.
And so the overall building coverage is only 12.6.
Am I correct? The village commercial zoning line is not the boundary of the parcel.
No, it goes right
Correct,
through.
okay. So it's the same parcel with a zoning line between it.
Yeah, the zoning line bisects the overall development, yes.
So we're giving, by my back of the envelope math here, 5.5 acres is about 240,000 square feet, give or take, with 11 duplexes. So each of them is getting roughly, if we're kind of looking just within that one village commercial area, about 22,000 square feet. Does that sound about right?
Yeah, I think so, yes, yeah.
Okay.
Just want to make sure, with duplexes in village commercial, the minimum lot size is 26,000 square feet per duplex. So how does that?
Because it's not the same criteria as a cluster. For the coverage of buildings in a village commercial in the zoning, it's just as long as you don't exceed the maximum coverage, which is 50%.
But if we look at the use table, the use table or the dimensions table, that duplex in village commercial has a minimum lot size.
Right, but if I was drawing them as individual lots, but, so if I made this multifamily is also allowable in village commercial, if I put all these buildings together and did a big multifamily building and covered 49% of the lot, that's also allowable. The fact that they're split up into individual buildings doesn't really change it's allowable in the zoning.
I see your route, yeah.
If I did one big giant multifamily building, that's 49% lot coverage, which is 4 times as much coverage as we have here. That's an allowable, by special permit, but an allowable use.
Understood.
It's the district, it looks unusual because you have a residential district and the village commercial next to each other, and you're looking at the density, if it was all residential, no, we wouldn't be allowed anywhere near that density. But that's not what it is.
Okay. Rob, you had your hand up in the Zoom meeting. Did you want to ask?
I was just curious here, because we're talking about just parcels and things. First of all, these aren't going to be rental units. You're selling them when you're done, correct?
Correct.
That was a yes/no question, sir.
He said yes.
Selling.
Okay. Okay, selling. Okay, so I don't see that as just two parcels, and I think every building really is a lot.
It's not, it will be in a condo association home ownership, because it is also a large shared septic system, and in your own regulations too, with the open space and with the septic system, there's regulations, and with it's going to be a private roadway. All of those things require maintenance, and there's common ownership aspects. That's all going to be bundled together under one, which the planning board will also have full review and control, and through town council and everything. I've gone through this process many times. With the language that goes in there, we'll all, be able to vet and negotiate out and make sure the town's protected, other neighbors are protected.
That's terrific. It's just not what I'm asking.
Okay.
So when you're selling these, though, a person buying one of these is buying an area of land and a unit, correct?
No.
They're buying the unit, and then they're buying into the fact that they need to be participants in the homeowners association and all of
They own the land.
They probably have usage rights for part of the backyard, but they don't, I assume that they
They're
would not own
purchasing
the
land.
They do not own the land.
No, they would just own the units, and they would have use probably for their backyard as.
That's the point I was trying to clarify. Thank you.
And then the shared costs that they would pay to go to maintain the septic system and the road and everything else that would go along with it, which we would require anyway. Yeah.
Again, this was all.
I'm just trying to figure out how you were describing this.
Sure.
Saying, I says, okay, I get how it worked.
Yeah. I'll see if other board members have comments here. I have a couple, but.
I don't particularly mind the proposal at all. One of my questions would be screening, what's going to be between the new structures and the existing residential? What do we got for distances, trees, et cetera? What do we have for buffer?
I'm not sure what Peter had already proposed, but I anticipated there's going to be some requests under the special permit for specific screening. I'm usually preference to natural screening,
Yes.
trees and the such, as opposed to fencing. Open to heights and species and all that stuff. I can have suggestions. And as distances, again, I don't know what Peter has proposed. It meets the setbacks. I know we drew a setback line all the way around, and it is similar uses. You have residential next to residential, so it doesn't, fall under a commercial use behind a residential and those setbacks. But again, we have some room to move things around a little bit of certain distances, and certain screening is preferred.
I'm challenged by this in a couple of ways. One, it's a lot of density, and going behind the existing uses. You talk about the flexibility of being able to move stuff around. This needs to be buttoned up at our next meeting, period, and that would be April the 15th. So we have tonight, and we have April 15th, and then you have 3 board positions that are turning over. And you need 5 affirmative votes who are able to participate in that decision. So if you want this board to give you a decision, that decision has to be on April 15th.
Okay.
Which means that we need to have everything buttoned up at that point, which...
Before
that point, which is challenging. You won't have gotten any from Concom, so you would need, whatever we would do would need to be contingent on Concom approval, and then you might need to do a modification depending on what Concom comes back with.
I think we're already have the analysis from COMCOM, and again, we would have had that replied back, except we were waiting on this meeting. So having the feedback from this meeting will be.
That's just the peer review on the drainage though. That's not their overall comments on crossing the wetland and everything else.
I think we already had preliminary feedback from the agent on his thoughts, and we already incorporated that into our design. So we were already one step ahead with our application. Originally, we were proposing a ADS culvert that was already upgraded to a box culvert at his request prior to even applying. So in stream crossing standards and other things, we had already gone through that level with him. So I think that from a Concom standpoint, we're probably going to be mostly set with that. It's really the peer review stormwater comments, which, if anything, after the next round of reviews would be down to minimal tweaks that I don't think would require much modification.
Okay. Paul, since we do have a cluster here, have they provided all the documentation around a cluster in terms of providing the alternate layout and everything else that our bylaw requires?
There were some things we received today. One, when I looked at the open space plan, it just wasn't, this map is better. I had a hard time seeing that in the plan.
Okay.
There were some other, let me just pull up my, stop sharing here, but. I just had comments too about the frontage and then the determination of the duplexes. We would need the landscaping plan and a lighting plan, showing if you have any signs, if you're where the signs are, like entryways to it. Also, we'd like to see the boundary of the wetland protection district on here. Additionally, how many parking spaces are you proposing on the site?
We have that on the plan, just gonna throw a table for that.
42, 42 total.
Okay.
42 total for how many units?
30 units, 15 duplexes.
So you have 1.5 parking spaces for the duplex units?
Is that
over the whole
Yeah, yeah, we have one parking space in the garage and one parking, so each unit has 2. And then we have an additional 12 visitor parking.
Okay, thank you. That answers my question.
And of course, with the cluster, there are ownership responsibilities of the homeowner association for the open space maintenance, as well as the common driveway. So that would have to be conditioned in there, but they've identified that the condo or homeowners association would be managing those, but we would have to write those in the conditions.
Again, for the common driveway, if that's a separate parcel connected by a common driveway, does it have frontage?
That's a question I have.
Then it does
That was
not.
a question.
If it's just the residential area,
There is a parcel that does not have frontage that I've seen. Now, you all mentioned that you were talking about this as one parcel, but the subdivision plan created for Harvest Farms, as I saw it, it looked like it created four parcels.
Those are existing.
Those are the 4 existing.
Right, those are existing, and that subdivision is still in effect. It was never rescinded as far as we can tell, so that one parcel toward the MBTA line, that doesn't have any frontage.
Right, so we can combine them all.
Yeah, you could.
We would combine them all to make one, but like it's just an overall, like when a site plan.
But we don't have an application to do that, do we?
but if they're all combined, you can't do a cluster development on village commercial, which is most of the lot. And that's where the frontage is and where it's starting from, the project. And exceeding far beyond 30 feet beyond the border of the zone.
So it's being a unique property with 2 different zones, and the frontage has to come through the village commercial to access the back part. How would the board like us to handle that, basically? Again, the Harvest was put through as a subdivision plan. We could easily just have the same layout as a subdivision plan, which would create frontage in the residential, because that road now is creating frontage. It's basically the same thing, because now we're gonna create frontage with that roadway. Now you have residential frontage, you have commercial frontage all over the place, but it's not gonna change the project at all. It just changes some of the filings and logistics.
A subdivision with individual properties in a zone, it's either village commercial or next to village commercial, has a lot of potential for individual houses, properties, and businesses. A homeowners association in a cluster development does not have any of that potential. You're putting houses on our village commercial area, not just one duplex, but 15 of them or so. It's a driveway across the wetlands, way farther than what's generally allowed. I think there's, what, 5 special permits? And each one of those is supposed to be considered as, to approve them if it's not substantially more detrimental than if we didn't approve it. If we didn't approve it, this property at maximum would receive 1 house or a warehouse under 10,000 square feet or a retail business. It would not, under any circumstance, without approval from this board, be of that scale. So you have to prove to us that it's worth for us to do it, it's good for the neighborhood, and it qualifies.
We believed, and I believed with looking at this property, again, a lot of the motivation was it was a project that was previously looked at and approved by the town. I understand not the individual board members. But I've met with staff on this project starting a year ago, and then more recently, and basically said, I'm looking at doing what was already approved, you know, what does the town think of that? And received pretty good support that the staff was in favor of, well, this was approved before, this looks good. We're in support of the general concept of it. Now looking at it as if it wasn't approved, keeping in mind the residential nature of the neighborhood. Again, this isn't running up a busy street. If it was a busy street, I'd maybe be looking at top of the shop housing or something with more of a commercial nature to it. You know, was creating some type of a roadway, creating frontage for village commercial, and then the residential on the backside. But I thought that being that most of the abutters there are in a residential nature, keeping it in somewhat of a residential nature, but also affording the ability of housing for the town, which I know is some of the needs, that's where I was looking at the benefit.
And I don't mean to be combative with you by any means. I understand your perspective of it all. You are a developer, you're looking to accomplish your goals and everything like that. I have criteria I'm meant to fulfill. I have an obligation to the community that I live in, the residents that I speak to very frequently. Your intention is to build this and then leave town.
I do live right next door in Rehoboth. I'm not going far.
I'm still saying, you know, like but genuinely, you have to prove that the project is worth doing because you're asking for a lot of exemptions, a lot of special permits.
Yeah, I agree with this.
Paul, can you, on the map, where is that parcel line for that 4th parcel that doesn't have frontage?
Let me pull up another.
Ballpark is fine.
It's up roughly.
It's part of the development, basically.
Yeah, part of
Is
it.
it?
Part of it.
There's no way to include, to use the development and not touch that parcel that doesn't have frontage. As it is.
Is that septic's going?
Exactly, yes. So,
I mean, that one parcel that's landlocked is being reserved. It's being preserved for open space. We're not proposing anything on that lot that's being.
well, the septic is there.
Well, the septic's not on that lot. The lot is that rectangle where that large wetland is and the 2 vernal pools.
It's after all it does is it boosts your open space percentage, basically.
It's being
Right,
preserved.
we're preserving it. I mean, there are 2 vernal pools there, so we are preserving all that upland that surrounds those 2 vernal pools. So
But
nothing will ever be.
Understood.
It's
Okay.
being preserved because it's unbuildable.
No, it is buildable. You still can build there. There's really no point of building a road out to that area, but you can build on it if we want, you know. I mean, you only have to be 125 feet away from vernal pools, so you could put a structure back there if we wanted to, you know. But we're preserved, like I said, we're preserving 66% of the parcel. So you're preserving all that area back there, as well as some of the area along the back portion and within the R60. I mean, we are concentrating, like Ryan said, the buildable area is isolated in that area. We're only disturbing 3 acres, basically, out of the whole 24 for the development. So you are getting a lot of environmental, you know, preservation with this. We are crossing that wetland, but that wetland is man-made. There's a man-made channel in that wetland. But we were asked to preserve that channel, so that's why we then changed the design and we put an open bottom culvert. So now you're preserving that culvert. We are going to replicate the wetlands that we are filling, and there is an existing cart path that runs from South Worcester Street all the way to the back area, and that restoration area is going to restore portions of the wetland as well as, you know, where that cart path crosses. So, you know, environmentally, this is much more, you know, better than, you know, putting in a cul-de-sac, putting in a subdivision road, which we could, and then, you know, you could put lots off that subdivision road, but I don't know, it just seems like this design kind of, it concentrates the area in the village commercial, and you're able to restore the portion of the lot that has the most environmental, you know, where it is critical to be preserved, and that's what we're trying to do.
Understood. So, speaking, Paul, did you want to add something here?
Just, I think building off of what Peter said, I mean, obviously one of the benefits of a cluster is where you have environmentally sensitive areas, you're allowing, you know, to reduce the footprint of the upland area being developed.
Yes. In this case, only those back 4 properties, but yes. So, other board members here, I was just going to ask if we're going to make a decision on this in our April 15th meeting, then I think what we need to do now is come up with, give the applicants any and all comments and concerns that we would like to see reflected in anything updated that they give to us. And we would want those updates available to us no later than April the 8th, so that we have time to review them ahead of our meeting. Rob, you have your hand up here.
Yeah, I was just curious because a point that got raised several times, it was even a response to technical questions by Steve, was that this was previously approved. What does that mean?
It means that at one point, the planning board thought that something like this was a good idea.
Does it mean anything to us today, though?
We are not bound by that decision in any way. It is expired.
Oh, that's why I wanted to know. I never understood how that was even a point that mattered. Okay.
The idea is that it's not something that the town has flatly rejected in the past. It's something that the board, that past versions of the planning board didn't think was acceptable and had approved under a slightly different configuration and layout, but that's planning board semantics.
That was then, this is now. Gotcha.
Yeah.
Okay.
I mean, normally I feel like we'd be instantly asking for town council's opinion on something like this, on a normal situation, if we weren't trying to.
In terms of evaluating how the different parcels and
Yeah.
common driveways and that kind of stuff.
100%. On a normal, something as complicated as this, we would definitely have a town council opinion.
Paul, do you feel like something like that would assist in this kind of
I just don't think there's enough.
delineation between the different areas?
Yeah, I think we can make that request.
I don't think there's enough time.
I think there is.
Is there?
If we're at the 15th, and if it's something you need to make your decision, we'll get it to town council.
And the specific questions are related to parcel without frontage, common driveway, and the dual cluster and duplex special permit, kind of dual parcel treatment. And that would just be town council weighing in with if there's anything that the board should consider as we review that, basically.
I think they just make us a little bit more comfortable that we're
On solid ground.
Correct.
From that perspective.
correct.
Understood.
Can I ask you a question?
There's also a whole list, there's a whole list from Paul, specifically from duplex requirements, 175, 50. There's a whole list from Paul that, I know they sent some responses today that I didn't get all the way through, but
Yeah, I didn't get
There's
through it all.
yeah, exactly. There's a long list of screening and off-site improvements and on-site, there's a significant list of things.
Yes.
This? Yeah.
So, the way that I understand it, and reflective of reaching out to town council, is, again, if we presented this as a subdivision plan to create 2 lots, one village commercial lot and one residential lot, each which would have frontage, that would bisect the 2 zones, and we would have a single lot meeting the village commercial criteria with multiple duplexes on one lot, and we'd have one residential lot meeting the cluster criteria on that residential lot, if we had a subdivision plan before you creating frontage. With that, I think the question for council is, without that, can those 2 lots be combined, and as long as they meet the criteria of the special permit in each zone, act as one lot utilizing the existing frontage on South Worcester Street? Because I do understand, you can't build on a lot that doesn't have frontage.
Yeah.
So, is that one combined lot, as long as it meets the criteria and is combined with the other lot, as 2 different zones, it's basically, if you had a parcel, like it is, in 2 different zones, that you can build what's allowed in those 2 areas under those 2 guidelines.
Yeah, I think that's the determination that we would be looking at,
Right.
is it okay as it is, or does it need to be in another form?
Right. And my thinking ahead, if it came down, the town council did feel it needed to be in a different form, our presentation would be the same format, just also presenting the subdivision plan creating those 2 lots.
Yes. My understanding is that if the town council said that what you're proposing here does not make sense, then your next move would be to ask to withdraw without prejudice and then come back with a revised plan. Absent that, I assume that you would still like us to proceed and
But yeah,
give you additional feedback and comments.
I believe
right
it works as
So-
it is, but the special permits that we have, I don't think would not apply. I don't think there would be a need to withdraw them as needed, but.
now. We don't have because we don't have a subdivision plan in front of us.
Right, absolutely.
And because you have the potential to lose 2 voting members in April 26th, and you need 5 for a special permit.
Right.
So unless you want to play for, I need all 5 on a special permit decision, then you may want to withdraw.
Right. Okay, well, I guess we'll see what town council thinks of it, so.
Other points, Alan, you mentioned screening to the existing residential. That would be something that I think would be a focus from my perspective.
Yeah,
That residential's pretty not dense. You can see back pretty far from those until you get to the tree line. And you're proposing 8, 9 duplexes just within line of sight of those buildings / a foundation with nothing on top of it, which isn't your fault, but just from a screening perspective, understanding what we're putting back there.
And also under site plan approval for 1 duplex under 175-15.3.b, it's in
Can you
Paul.
wait for the mic just, Alan?
Sure.
Sorry.
It's in Paul's memo. We could also ask for requirements for off-site improvements to improve the capacity and safety of roads, intersections, pedestrian ways. You brought it up yourself. I'd be right off the bat asking to, sorry, the plan's not up, maybe improve the sidewalk in between the driveway and that other strip of land, something like that, because you know that's going to be used for some type of walking.
It's not a great stretch of South Worcester you're
That's
coming out of.
going all the way up to Harvey Street, so it's not,
No, I'm saying it might not be, I'm just throwing it out there, it might not be on our purview to ask for off-site improvements as the bylaw says, between
Okay.
the driveway and say that where the water's gonna be looped.
yeah, I mean, of that whole stretch, that's probably the best piece of that sidewalk, for better or for worse, mostly for worse.
Could I know,
Probably only a foot wide when you closer to Harvey.
I'm definitely interested to hear, so we can get all this out as the board members' input on screening, and I just have one other thought. Because the other definitive plan was already done, and currently exists, I know we're changing the roadway, so that might need to be modified. How does that factor into it as well? Because that definitive plan would have created those lots necessarily.
It's not what's in front of us, so we can't look at it.
Well, I mean, it already was done and recorded.
It's not what you proposed.
It's not what you
So-
proposed.
Didn't we discuss that we don't care about the past?
Yeah.
You would be asking us to, in theory, if you took that, put it in front of us, to act on it in our next meeting in its entirety.
Right.
Without having an opportunity to give you feedback on it and have you iterate on it. So I don't see that as a workable solution.
Okay.
Additional comments, requests that we would like the applicant to review outside of what Paul has noted in his memo here.
All the operations and plans, everything, I think we covered it, we would have to condition, right, because those won't be ready. Operation and maintenance plans.
Yeah,
And,
those are all part of the cluster requirement.
Yes, but those probably won't be ready, so that would be
Yeah.
conditioned.
Yes. So, Paul, is there anything else outside of your memo, which I assume the applicants already have? Anything else that, after our discussion today, that you think is important for them to provide prior to the 15th?
No, I think we've stated it.
Okay.
So I will get an email off to town council.
Do we still need to vote on that?
I haven't heard otherwise, but, I mean, we could just say that we.
I'll make a motion that the board request guidance from town council on this issue.
So moved.
I was gonna undo the motion.
Oh, seconded.
Any further discussion? Hearing none, I'll go through the roll. Steve?
Yes.
Alan?
Yes.
Eric?
Yes.
Jim?
Yes.
Rob?
Yes.
And I'll vote yes. So if we needed to have a vote, now we have. Okay.
Now we can ask the town manager politely if we can. Is that what you mean?
Yes, exactly. Yes.
Can I just ask, I know lighting came up, is there guidelines for lighting, or should we follow regular subdivision control lighting requirements, or for
I think
street
that was one of the
lighting?
things, Paul, that you highlighted, that we didn't have a landscaping or a lighting plan, and they're both required.
I would go through the site planning.
Okay.
There's a provision outside of subdivision in the zoning
Inside.
bylaw.
Okay.
And I would put an emphasis on making sure that we're not putting light onto the abutting residential properties.
One thing I think they're safe.
Pretty sure that MCO pool lot's lit all night long. Anything else? Okay.
April 15th is what we're looking for, the continuance?
They're not gonna be back before Concom before the 14th.
Yeah, so,
And our 1st and 8th are full.
so 15th.
That would be my,
So I'd motion to continue SPR 11, SP 19 and SPR 12 to April 15th.
Seconded.
we have a motion and a second. Any further discussion or comment from you? Okay.
You continue to which, did the 15th?
15th.
Let's make sure, okay?
We're gonna vote on it right now. Steve?
Yes.
Alan?
Yes.
Eric?
Yes.
Jim?
Yes.
Rob?
Yes.
And I will vote yes as well. Okay. Thank you very much, gentlemen. Sorry I had to listen to our entire zoning recodification, but sometimes it happens.
All right, thank you, have a good night.
Thank you. Okay.
Motion to adjourn?
Not yet, sorry. We still have minutes to approve.
And we have the decision.
And we have the decision to review. Paul, you sent that out, correct?
Yes, it's coming up.
So, at our last session, we said that we would share the decision for 360 South Worcester Street before it was filed. Paul had sent it out, just making sure that no one had any specific comments that they wanted to raise. If there are none, then we'll get it to Laura to sign, and we'll move forward. But all the conditions on operating hours and everything else were generally consistent.
I was going to abstain on that, so I'm still out.
Paul, you had said that basically like this actually isn't that different than any other decision, but I had said we wanted to bring it back to us, so we are. So if there's nothing else, we'll move on. And we have 6 sets of minutes on the agenda. So the first set of minutes that we had on the docket to approve was from July the 30th. Any questions, comments, or concerns?
Motion to approve.
Seconded.
Second.
Thank you. I'll go through the roll. Steve?
Yes.
Alan?
Yes.
Eric?
Yes.
Jim?
Yes.
Rob?
Yes.
And I will vote yes. Next is the minutes from August the 6th. Any further comments?
Motion to approve.
Seconded.
Okay. Steve?
Yes.
Alan?
Yes.
Eric?
Yes.
Jim?
Yes.
Rob?
Yes.
And I will vote yes. Next one is August the 20th.
Motion to adjourn. Approve.
I hear the motion. Thank you, Rob. We have a second.
Second.
Okay. Steve?
Yes.
Alan?
Yes.
Eric?
Yes.
Jim?
Yes.
Rob?
Yes.
And I will vote yes. And then we have 2 sets of minutes from the 10th, Brian. Is it 2 different documents?
What was the 10th?
September the 10th?
Was that? That was our joint meeting, right?
No.
So
I don't have it pulled
I'm
up.
gonna look back to see which one.
Yeah, let me note that we didn't do, let's skip the 10th, and we'll do just the last one here, and we'll add the September the 10th to the next one. So the final one that we'll look at tonight is October the 8th. Any
Motion to
questions?
approve.
Rob, I heard your motion to approve.
No, but I'll second whoever did say that.
Oh,
Sorry.
I did.
sorry, Eric.
It's okay.
We have a motion and a second. Any further discussion? Hearing none. Steve?
Yes.
Alan?
Yes.
Eric?
Yes.
Jim?
Yes.
Rob?
Yes.
And I'll vote yes. So we'll leave September the 10th alone.
Maybe if it
I
was,
don't trust myself at this point in the evening, so.
maybe there's 2 because there's a second September meeting. That doesn't seem to be there, so.
Yeah, it might be the later September meeting, but just in terms of the dates and the file names,
Yeah.
I just want to be clear. So I'll just leave them alone and we'll just correct that. And,
It's best to fix it and come back. It's a minor deal.
yeah, and that's why I left nothing on the 15th. Any objections to moving any remaining minute approvals to our April the 15th meeting?
None.
That means we don't talk about it on the joint meeting next week, which seems like a good idea.
That'd be terrible, wouldn't it?
Speaking of that, is it still at 7:15, or I heard there was a rumor of moving it to 6, or what?
That was a discussion that I got. I was informed previously that there was only a small number of people from the select board who wanted to move it earlier. The latest update that I got was that the select board may or may not have a quorum if we start at 6. So that would be for April the 1st. So again, this is just a question of,
If we start at 6 or don't start?
If we start at 6, or did you mean they won't have a quorum if we don't start
Don't
at
start at
6?
6.
If they don't start at 6.
if we don't start early, they may not have a quorum.
I was asked if I could.
I can start early.
I thought it was the other way.
Tim, you guys haven't made me do that much, so I can do that. I can block myself off work.
I will, so I would say,
You guys have been great about
He's
meeting
looking
times.
to-
I can,
the request from the select board chair was to bump it up to a 6 or 6:15 start. Saying that
6:15.
they may not have quorum if they can't move the time up earlier. So, are we on, do we have objections to moving it to 6:15?
I'm available.
I'll be traveling, I'll try to be on.
Okay.
I'll make myself available for that.
Other objections? Otherwise, we'd look to bump the April 1st to 6:15 per the select board request.
April 1st or 8th? That was 1st, okay.
First, yes.
April Fool's Day, yeah.
Well, I am a fool, so. Okay. I don't
Well, I
think we
just
need to
think
vote on
we
that,
did it.
but I'm not hearing any
6 or
strong
6,
objections.
6 or 6:15, what'd you say?
I'm gonna say 6:15.
Perfect.
Yeah. Get 6:15, just,
So, Paul, that was a request I got from the select board chair today.
Okay.
That they may not have quorum if we don't bump it up. So, we will do that, and I'll see everybody in a week.
Awesome.
Rob, did you want to make your motion now?
oh yeah, motion to adjourn, sorry. See, I'm starting to doze off on you.
Do we have a second?
Seconded.
Second from Steve. Okay, and I'll go through the roll again. Steve?
Yes.
Alan?
Yes.
Eric?
Yes.
Jim?
Yes.
Rob?
Yes.
And I will vote yes. Thank you very much, everybody.
Have a good night, Al.